This matter is fixed to today. Two matters, your lordship, specifically fixed today. Despite that, matter is not come.
So kindly give the date also.
Yes.
Earlier date. Okay.
Earlier date. Sure.
Because I am not giving any date, I am just arranging it. Fresh admission orders, then up to notice. Of course, special reference and other special bench. Yes. Item 2 to 8, page 1.
Page 1, item number 4, my lords. I pray for an adjournment.
Your name, sir, Mr. Das.
My lords.
Mr. G. Das.
My lords.
The trial court execution is pending.
My lords, my lord, as per your lordship's direction, my lords, the petitioner had approached the trial court, my lords. The trial court directed to pay the installment amounts, the amount of maintenance, my lords, in installments.
Which direction?
My lords, your lordship may see order dated 5-2.
Which paragraph? I'm only looking at 5.2.
My lords.
Which direction? When you are attributing something to the court, be sure that the court has passed any order directed you.
My lords, may see para number 6.
Yes. Which part is the direction?
My lords, your lordship are directed to
Kindly read,
seek
sir.
instruction.
Lordship has never directed, sir. Kindly read, sir. Don't look at my face.
My lords, learned counsel for the petitioner has adjournment to obtain instruction regarding how the petitioner will secure the direction for payment of monthly maintenance, which is in nature of money decree as directed by the Honorable Apex Court.
So which is the direction part?
My lords, to this, my lords.
Or I should have dismissed on that date.
No, my lords.
You see, when you are seeking adjournment for obtain instruction, it's not court's direction.
My lords.
Either you do not understand what you are submitting, or you are too smart, or you are understating the court, saying that the court has directed nothing.
Pursuant to this, my lord, so the court has directed to pay the amount of maintenance in installment.
Sir, this cannot be, sir. You are seeking adjournment since August 2025 on one petition or the other. The matter is adjourned, was adjourned by order number 1 dated 6/8/2025, 2 dated 16/9/2025. Thereafter, it was heard at length on 5/2/2026 by this bench as reflected in the said order. Again, the matter was adjourned on 26/2/2026. Apparently, after filing of the application, when it was presented before this court in August, July or August, in June 2025, in one petition or the other, the matter is kept adjourned. Execution, it is stated by the learned counsel for the petitioner on instruction that execution is pending before the learned judge, family court, Fulbani. Yes. Pendency of this petition shall not be barred for the court, for the learned judge, family court, Fulbani to proceed in the matter in accordance with law. In view of the judgment rendered by the apex court, larger bench decision in Rahul Shah, as well as Rajneesh versus Neha. Stop. Citation delivery. Copy of this order shall be forwarded to the learned judge, family court, Fulbani. Yes, next. As prayed for, how much time you want?
2 weeks, my lord.
The learned counsel for the petitioner seeks 2 weeks further time, though there is no apparent reason for adjourning the matter. Stop. Sir, don't invite this court to be a party to your machinations. High Court is not your agent, or you are not the agent of the petitioner also. You are officer of the court. By one petition or the other, you are frustrating a decree, money decree. And you are looking at so apologetic as if it is your own case. If it is your own case, don't appear in your matters, personal matters. Only a person who says that I will not comply, let him face the consequence. But don't make the High Court a party and you become the process in the process also become a party. As paid for details, the blooded counsel for the petitioner 6 and has 2 weeks time, 2 weeks further time. List in the week commencing
27 sir.
27/4/26. Published.
Page 2, 9 to 18.
Item 9, my lord, on behalf of Mr. Achari, I pay for an adjournment, my lord. He is not.
Your name, sir?
S. Das, Shubhankar Das, my lord.
Yes, Das on is Das for the petitioner. Adjournment is sought for by the learned counsel for the adjournment is sought for on behalf of the learned counsel for the petitioner. In absence of the learned arguing counsel, stuff. The matter shall be listed in the week commencing
27 sir.
27/4/26. Yes, next.
Grateful, my lords.
Item number 18, maybe permit to withdraw this matter.
18 number is.
Objection to withdraw.
What's your name, madam?
Das.
Who has signed the memo?
Petitioner.
Who has signed the memo? Memo ki दस्तखत करछन्ती वकील को ना करछन्ती से निजे दस्तखत al bracket रे ना लिखि दियो. Yes, next. S3 item 19 to 26.
Page 4, 27 to 32.
31. 31.
31.
Belongs to the opposite party. Name is not indicated in the list.
Mr. Satpathy
It is a
obtain change.
it's a transfer brief.
तो फिर से अर्जुन डेट कर दियो तो
In this short day.
शॉर्ट डेट करियो बन शॉर्टेज डेट रो करा होचे फिर
Will commencing 4 तारीख.
Good. Indicating my names.
सेटा से करिवे ऑर्डर किछि होनी आपण फाइल करते.
Great.
Page 5, 33 to 38. Page 6, 39 to 40. Page 1, item 1.
इनपुट first. Kindly give a memo पे पूरे काम कागज पे. मेरे को ऑर्डर का ऐसे डिस्प्ले. Order number 4 dated 7/3/2026. Mr. J.K. Mishra true for the petitioner. Mr. Samal is there. Mr. Devasis Samal for the opposite party. Para 1, 2, 3 टा repeat कर देले. तापर लिखिए 4 para लिखिए. Order number 4 para 1, 2, 3. That would save time. Just reproduce. Para 4 है कि as directed by the order dated 7/3/2026, report from the learned judge family court Balasore has been received. By letter dated 23/23/2026 addressed to the registry of this court. Stop. The stop. The said data indicates that CP number 193 of 2016 has been disposed of on 16/3/2020 on contest. On contest. Stop. The records have been consigned to the record room on 14/9/2020. Stop. In view of the above, nothing survives in the petition. The petition stands disposed of. Yes, next.
Item 2.
No instruction. You have no instruction.
No instruction ta orally कहबनी. Once you file wakalat tama, you have to give it in writing. Memo diyo. So what do you want the matter to be disposed of? Apan ko na madam?
Yes, Mandy.
Okay?
S. Mohanty. So Nandini Mohanty.
MS dot S Mohanty for the petitioner. Can you step in? The matter was presented before this court on 16/10/2021. Stop. The petitioner husband in the marriage is before this court, challenging the judgment dated 16/8/2021, passed by the Lord Judge Family Court Dhenkanal in CR.P. case number 84 of 2017. CR.P. number, case number, CR.P. number 84 of 2017. By the said judgment, the petition filed by the wife in the marriage under section 125 of the petition filed by the mother of the opposite party as well as mother and father mother of the opposite party cutting it out to by the order mother of the opposite parties before the learned family judge under section 125 CRPC, claiming maintenance from her sons was allowed. Stop. The learned judge Family Court Dhenkanal directed ₹5,000 to be paid by each of the sons plural, each of the sons. Stop. After almost 4 years of filing the application, the matter was listed for removal of defect before the Deputy Registrar Judicial into bracket Lojima. Stop. The Deputy Registrar Judicial, by order dated 21/11/2025, granted 2 weeks time to remove the defects. Stop. Thereafter, almost after 5 years, the matter has been listed on 7/3/2026. When time was sought for by the learned counsel for the petitioner to remove the defects, which was allowed. The defects, which was allowed. Stop. The learned counsel for the petitioner submits that she has no instructions to prosecute the matter. Stop. Files memo of date, which states thus. The memo shall be taken on record, scan copy be updated. In view of the above, the petition stands disposed of. Yes, next.
Item 3.
Yes, next. Pass over कर दियो तो तारे fresh उड़ा का author डाकी देगा तो.
Item 5.
Author डाकी देगा. Pass over कर दियो.
Item 6.
और जब डाकिले परे pass over को होना है. Pass over कोई देवे ना. ये VC रहती है वैसे जानी भी परिवेन ना. समझते हैं कोर्ट डिप्शन दिया अपना करो. सार और सर. सार को रहते कोई सार कोई नहीं. Pass over कोई नहीं. ठीक है जी.
Item 6.
Next.
7.
Next.
8. 9.
अरे कौन अपन को अनुभव भी ना.
Item 8, my
Mr.
lord.
Biswajit 8 लिखो तो Mr. Biswajit Mahapatra for
Transfer of the civil proceeding from Judge Family for Kotak to Guardianship.
and she has no independent income, and she is staying with her family, with parents' house at Puri.
How many cases she has filed against the
The
husband?
one case that is section 9 she passed she filed କରିଛ Puri, and ସେଟା କଟକରେ ଆଜ୍ଞା ସେ ମାନେ ଅପୋଜିଟ୍ ପାର୍ଟି ଫାଇଲ କରିଛି, ହଜବେଣ୍ଡ ଫାଇଲ କରିଛି 13 ଆଜ୍ଞା।
ଆପଣ କଟକରୁ ପୁରୀ ଚାହୁଁଛନ୍ତି?
ଆଜ୍ଞା।
ଆପଣ ICD ରେ ଆପଣ ତ ଅଲରେଡି ଅର୍ଡର ଅଛି 26/2 ଅର୍ଡରଟା ଦେଖନ୍ତୁ। 26/2 ଅର୍ଡରଟା ଦେଖନ୍ତୁ। Have you obtained instruction in that?
ମୋ ପାଖରେ ସେକ୍ସନ 9 ରେ ଯଦି ଜଜମେଣ୍ଟ ହବ and ସେକ୍ସନ 13 ହବ, ଦି ଟୁ ସେପାରେଟ।
ନାଇଁ ଆପଣ ମୋର କାହିଁ ଲ କ୍ଲାସ ନଉଛନ୍ତି? 9 ଆଉ 13 ର ସ୍କୋପ ମୁଁ ବି ପଢିଛି ଜାଣିଛି। ଆପଣ ଯୋଉଟା ଡିସ୍କସନ ହଉଛି ଟ୍ରାନ୍ସଫର ସେକ୍ସନ 24, 9 କି 13 ରେ ଟ୍ରାନ୍ସଫର ନାହିଁ। ସେକ୍ସନ 24 CPC, section 9 of CPC, 19 of Hindu Marriage Act. ଆପଣ 9-13 କଣ କହୁଛନ୍ତି?
ମୋର ଦିଟା ସେପାରେଟ ଜଜମେଣ୍ଟ କିନ୍ତୁ
ଆପଣଙ୍କର 9-13 ସେପାରେଟ ଜଜମେଣ୍ଟ କେମିତି ହବ?
should be attacked analogously।
ଆପଣଙ୍କର ଏଟା ପୁରୀକୁ ଯାଉ।
ଆଜ୍ଞା
ହଜବ୍ୟାଣ୍ଡ ର କିଛି ରାଇଟ ନାହିଁ ଟୁ ପ୍ରୋସିକ୍ୟୁଟ ଏ ମ୍ୟାଟର, ଏଟା କୋଉ ଲ ରେ ଅଛି ଏଟା?
ନା ସେଇଟା
ସେଇଟା ଆପଣ କହୁଛନ୍ତି ନା? ଆପଣ କହୁଛନ୍ତି ଯେ ଯୋଉଠି ମୁଁ ନ ଫାଇଲ କରିବେ ୱାଇଫ ସେଇଠି ସବୁ ଜାଗା କେସ୍ ହବ, ତ ସେଇ ଜିନିଷଟା କୋଉଠି ଅଛି?
ଜଜମେଣ୍ଟ ଅଛି।
ହଁ ଦେଖାନ୍ତୁ ସେଟା। କେତେ ଦିନ ନେବେ ଦେଖିବା ପାଇଁ?
ଆସୁ
ଆପଣ ଅର୍ଡରଟା ଅଛି? ଆସୁ କଣ, ଆପଣ ଅର୍ଡରଟା ତ ଦେଖିକି ନାହାନ୍ତି। 26/2 ଅର୍ଡରଟା ପଢନ୍ତୁ। ପାରା 3 ଦେଖନ୍ତୁ, ପଢନ୍ତୁ। ଆପଣ ପଢୁଛନ୍ତି ନା ନାଇଁ? ମୁଁ ପଢିବି? You have to tell me, sir. We are wasting time, sir.
This court filing CP number 436/20 by the wife at a particular place which is under trial before the particular court cannot be a ground for transfer of CP which is pending for the court of competent jurisdiction. Further, it is submitted that the petitioner has no independent income. In response to said submission, it has to consider whether the persons having no independent income has easier or better prospect to prosecute the matter at Puri instead of Kottaka.
ଫେର କୋର୍ଟ ମୁଟ୍ ହେଇଗଲେ।
Further, both the courts of at Puri and Kottaka has large number of pending interment cases. By the transferring the case from Kottaka to Puri, the petitioner does not yet get any advantage as far as the constitutional disposal of the matter is concerned. At both places, she has to seek legal assistance from lawyer who shall appear on her behalf. If other parties can avail the ICT facility conducting both cases. Town being transferred matter has to renumber to be a yes Puri, though it is pending since 2025. Instruction application. Para 6 instruction application.
Then again you took adjournment on 19/3.
ଆଜ୍ଞା
19/3 ଆଉଥରେ adjournment ନେଲେ।
ଆଜ୍ଞା
Again at end of March ଫେରେ। थर्टीन रो सीपीटा कोठरे को पेज रे लगेछंती आनेक्स करछन 13 टा।
ଆଚ୍ଛା 13 ଟା ଆଜ୍ଞା ଲାଗିଛି ପେଜ 8 ରେ।
ଆପଣ ନୋଟିସ ଟା ଲଗେଇଛନ୍?
ସେ ନୋଟିସ ଟା ସେ ନୋଟିସ ପିଟିସନ ଅଛି।
ପିଟିସନ କାଇଁ? ଛେପ ମାରଲେ କଣ କାଇଁ ଛେପଡା ମାରୁଛନ୍ତି? ଆପଣଙ୍କର କଲିକତା ଆଡ୍ରେସ ଦିଆଯାଇଛି?
କାଲକାଟା ସେ ରହୁଥିଲେ ଆଜ୍ଞା। ନାଉ ହି
ଆପଣ ଆପ୍ଲାଏ କଲେଣି?
ଅପୋଜିଟ୍ ପାର୍ଟି
ଆପଣ ପୁରୀରେ appear କରିଛନ୍ତି 13 ରେ
13 ଆଗେ ପୁରୀରେ ଆମେ ଫାଇଲ କରୁଛୁ, ୱାଇଫ ଫାଇଲ କରିଛି
13
ନାଇଁ 13ଟା ଫାଇଲ ହେଇଛି, ହଜବେଣ୍ଡ ଫାଇଲ କରିଛି କଟକରେ ଆଜ୍ଞା।
କଟକରେ। ହଁ, ଆପଣ ତ ପୁରୀ କଲିକତାରେ ରହୁଛନ୍ତି।
ନା କଲିକତା ଆଜ୍ଞା, she was serving at କଲିକତା। କାଲକାଟା ହଜବେଣ୍ଡ ସର୍ଭିସ କରୁଥିଲା।
ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ ଆପଣଙ୍କର କଲିକତାରେ ଆଡ୍ରେସ ହେଲେ ମୁଁ ହାଉ ଆଇ ଡାଇରେକ୍ଟ ପୁରୀ।
ନା କାଲକାଟାରେ ହଜବେଣ୍ଡ ସର୍ଭିସ କରୁଥିଲା, କାଲକାଟା ହଜବେଣ୍ଡ ସର୍ଭିସ କରୁଥିଲା।
ଆପଣ ବୋଧେ ପଢୁନାହାନ୍ତି ଆଉ।
ଆଜ୍ଞା
10 ପୃଷ୍ଠା ଦେଖନ୍ତୁ, ପିଟିସନର 10 ପୃଷ୍ଠା ଦେଖନ୍ତୁ। ଆଦିତ୍ୟ ଦଳେ ଲେଖା ହେଇଛି ତୁଳସୀପୁର ବିଡାନାସୀ। ଆପଣ ହଜବେଣ୍ଡ ଆଡ୍ରେସ କଣ କହୁଛନ୍ତି କଲିକତା ବୋଲି? କଣ ସାର୍ ଆପଣ କଲିକତା, ଆପଣଙ୍କର ୱାଇଫଙ୍କର ଆଡ୍ରେସ ହଉଛି କଲିକତା। ଆପଣ ଯଦି ୱାଇଫଙ୍କର କଲିକତା ତାହେଲେ ପୁରୀ କାହିଁ ଟ୍ରାନ୍ସଫର ହବ?
ୱାଇଫ ଇଜ ଷ୍ଟେଇଂ ଆଟ୍ ପୁରୀ, ବାଲିସାହି ପୁରୀ ରହୁଛି ଆଜ୍ଞା। ସେକ୍ସନ 9% ଦେଖନ୍ତୁ।
ଆପଣ ଟିକେ ଦେଖିବେନି 10ଟା ଆଉ। ଆପଣଙ୍କର ପରମାନେଣ୍ଟ ଗୋଟେ ଆଡ୍ରେସ ଦିଆଯାଇଛି, ଡକ୍ଟର ଅଶୋକ କୁମାର ବେହେରା, ବାଲିସାହି। ପ୍ରେଜେଣ୍ଟ ହଉଛି ଫାର୍ଷ୍ଟ ଫ୍ଲୋର, ଫ୍ଲାଟ ନମ୍ବର ସୋଆନସୋ, ନ୍ୟୁ ଟାଉନ, କୋଲକାତା। ତାଙ୍କ ବାପାଙ୍କ ଘରଟା ହଉଛି ବାଲିସାହି।
ଅଶୋକ କୁମାର ବେହେରା, ସେ ତାଙ୍କର ହଜବେଣ୍ଡ ଫାଦରଙ୍କ ଘର ସେ ରହୁଛନ୍ତି। ପିଟିସନ ଇଜ ନାଉ ଷ୍ଟେଇଂ ଆଟ୍ ଫାଦର୍ସ ହାଉସ, ବାଲିସାହି।
ଆପଣ ତାହେଲେ ସେକ୍ସନ 13 ଡିସମିସ୍ ହେଇଯିବ। ଆପଣଙ୍କର ଜବ୍ କରୁଛନ୍ତି ବୋଲି ଆପଣ ଦେଖୁନାହାନ୍ତି, ମତେ ଅନେଇଲେ ସେ ପ୍ରୋବ୍ଲେମ ହଉଛି। ମୁଁ ପଢିବି, ଆପଣ ମତେ ଅନେଇବେ। କଲିକତାରେ କଟକ 13ରେ କଟକର ଜୁରିସଡିକ୍ସନ ନାହିଁ।
ଆଜ୍ଞା ସେକ୍ସନ 9% କିନ୍ତୁ ସିଲେକ୍ସନ
ଆଜ୍ଞା ସେକ୍ସନ 9 ଆପଣ ଆଚ୍ଛା ଅବସେସ୍ଡ ୱିଥ୍ ସେକ୍ସନ 9। ଆପଣ 13ରେ ଆପଣ ଜିତିବାକୁ ଚାହୁଁଛନ୍ତି ନା ହାରିବାକୁ ଚାହୁଁଛନ୍ତି? 13ଟା ୟେସ୍ ମିଷ୍ଟର ମହାପାତ୍ର, 13ରେ ଯୋଉ ଆପଣ ଅପୋଜିଟ୍ ପାର୍ଟି ୱାଇଫ, ଆପଣଙ୍କ ସେକ୍ସନ 9 13ଟା ଡିସମିସ୍ ହେଇଯିବ। ଆପଣ ଯୋଉଟା କହୁଥିବେ କଲିକତାରେ ଯଦି ସେ ତାଙ୍କର ଆଡ୍ରେସ ଦିଆଯାଇଥିବ। So what the High Court will do? You will appear before the trial court and say that ସେଇଟା ଆଜ୍ଞା ବାରମ୍ବାର ହଜବେଣ୍ଡ ଫାଇଲ କରିଛି, କେତେ ଥର କହିବେ? ଆପଣଙ୍କ ଆଡ୍ରେସ କଥା ପଡିଛି 13ରେ ଯଦି ସିଏ ମେନସନ କରିଛନ୍ତି, so you take that to be
by the husband, not by us.
so then you have to tell the court that your place of residence is not at Kolkata. ମୁଁ କିନ୍ତୁ ଚେଞ୍ଜ କରିଦେବି। How the court in transfer application will change the address also. ମୁଁ ମାନେ କୋର୍ଟ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ। This is only a strategy to delay the counseling. Somebody serving in Kolkata doesn't have any difficulty to appear before the trial court. Suppose she says that the court has no jurisdiction. That's a different thing. If she wants, then she can appear in Kotak also. How does it make it convenient for her to at Puri? You can yourself appear, represent her in Kotak. The matter was heard further. The learned counsel for the petitioner was again the matter was heard further. Stop करते regarding the issues regarding the legal issues raised in the order dated 26/2/2026 and reiterated on order dated 19/3/2026. The learned counsel for the petitioner has adjournment to obtain instruction. Stop. List in the how much time?
2 weeks time.
2 weeks time prayed for. List in the week commencing 4/5/2026. Yes, next.
Item 10.
Sir, 500 वर्षे कितना
Seats never.
ठीक है ଆପଣ ଫ୍ରେଶ ନାଇଟ୍ ରହିଯାନ୍ତୁ। ଆପଣ ଯଦି ଅନ୍ୟ ରଖିବ ମ୍ୟାଟର ୱାଜ କଲ୍ଡ।
The petition is about holding elections. The
We are appearing for the opposite party. You have entered appearance, madam. Copy of the representation may be served and it may be called tomorrow, day after tomorrow, any day election.
Tomorrow?
Tomorrow difficulty.
Anything convenient. Cannot. They are
Issue
seeking
is
for,
very simple.
they are seeking for a direction to hold election. Obviously, the election cannot be done by tomorrow or day after tomorrow.
The issue is very simple. It needs no great law point to be argued here.
No, that
If there's a bylaw, the term is over. As per the bylaw. So I am not saying I'll get elected or X or Y or Z.
No, it is a society registered
will-
under the Societies Act.
That will benefit everybody.
Therefore, whether a writ will be maintainable or not, it has
Writ
been
petition will be eminently maintained. my lords.
it has been clearly decided by different benches of this High Court that writ against a society doesn't lie.
Short of
My
the
lords.
maintainability issue, my lords, what is very surprising in this application is the fact that a person who espouses the cause of sports and who is a member of the society, the managing committee, comes and puts an application suppressing 2 minutes, two consequent minutes of the resolutions passed by the association where he was present. He suppresses that. And what is even more surprising, that he is oblivious of the fact that a new legislation governing the elections of this association has come into place. And the Government of India has also issued a notification whereby elections have been asked in view of the new promulgation of the law. The Government of India has now said that all the associations shall have to adhere to the new legislation which has come in place, and for which the elections should be deferred for 6 months up till the end of December 2027. This is the position. All these facts have been suppressed.
There is
Counsel is absolutely unnecessary.
there is no such mandate by the government of India. I'll tell you, Lordship, what.
How many caveats have been filed? So,
I'll tell you one caveat.
Caveat
Only
has
one
been served on the last.
I'll tell you, Lordship, Supreme Court in the BCCI case, this very matter was sub judice before the Supreme Court, and Supreme Court directive is there. Direction of the Supreme Court is there that you can't continue beyond the term. Huge amounts of money is being transacted.
My lord, my understanding is referring to an order of the BCCI case, which has subsequently been modified.
Kindly bear with me. Kindly bear. Don't.
My lord, I am appearing for BCCI.
so what this court can do is that
Obviously,
I mean any opposite party coincidentally has been made also a caveat.
I am a caveat.
there's one caveat.
My lord.
There's one caveat.
Opposite party.
Copy the
The Mr. Subbu Palis
and
here
court issue, my lord.
along with Mr. Amitabh Misra. Just give me a minute to just complete my appearance. So with Amitabh Misra for the petitioner, Mr. I mean petitioner in plural, both you are appearing
I'm appearing for.
for the petitioners.
My lord.
Mr. Prem Kumar Mahanti
One
for
and
the OP number 1 and
8.
8. Acha, 1 and 8. Okay. 1 and 8. Who else have filed wakalatnama? You have filed.
I'm filing for BCCI.
Today. Just 1 second. Anyone already on record? Any learned instructing counsel on record?
We are for opposite party number 5. Vice President.
Mr. Mukherjee, you are also appearing today.
No, I have lodged my caveat. I have lodged the
Okay.
caveat. I
Mr.
will serve
Gautam Mukherjee, senior counsel, along with Mr.
Mr. Amlan Mishra. Mr. Amlan.
Amlan Misra. So Amlan Misra appearing for
Opposite party number 6.
Joint Secretary, Odisha Cricket Association.
Sorry, my lord.
Sir, Joint Secretary, Odisha
Yes,
Cricket Association.
yes, my lord. Yes.
Caveat. Member 6. Appearance के लिए ठीक रहेगा.
My lord, I am also appearing.
Just 1 second. Sir, which is on record happening.
Already I was there.
No, so that type of नहीं लिखिया था no ठीक no. Just give me some time. there is some method in doing the things. Some method. समस्त का appearance चालू है. I told me your senior that only that I'm recording the appearance now. किती appearance आपण type करू आपण लिखिए. It is submitted by the learned senior advocate Mr. Sheikh Mahanti, appearing along with Mr. Jaideep Pal. That Mr. Pal has instructions to appear on behalf of
Opposite parties. Five.
Bachchan. Shubhila and Kasi. OP number 5, Vice President Orissa Cricket Association.
Aye.
OP number 5. The Wakalatnama, duly executed Wakalatnama shall be filed during course of the day along with appearance memo of the learned senior counsel.
Then it's it.
No, Mr. Mahanti's Evar has, Mr. Pal has already been served a copy last day. His appearance was there on the last date. We have served a copy on everybody. Mr. Mukherjee, Mr. Nanda, Mr. Patnaik, Mr. Pal, everybody has been served copies. Same day itself, the last date. 24/3 we have served copies.
But that's a different bench or?
No, that's a different bench. But since they appeared, court directed.
So this is the determination of this bench or that bench?
No, it was before Justice Raut Rai.
Subject matter.
Subject matter of this code, I believe, because
Now
the body, the election, the body to which election.
The direction was in the meantime, petitioner is directed to serve a copy of the brief on the counsels appearing for the respective opposite parties. So all the copies have been served. Service the hating of it. They have been served. Everybody has been served. We have filed the receipt. Receipt has already been
This is
filed.
determination of whether Justice Raut Rai or my determination. Actually, I didn't look at that.
No, it was before, my lord, it was like this. It was before Justice Raut Rai.
In fact, it has been served in the office.
Acha. Again. So it initially was listed by the registry before Justice Raut Rai. Then, my lords, probably an argument was made that it may not belong to that the assignment of that bench.
It's not that.
So therefore, the registrar again reassigned the matter before your lordship.
Do you have copy of this assignment?
I have it.
Because
I have a copy of this.
All residuary matters is Justice Raut Rai's assignment.
Yes, that is what I submitted on the last occasion.
Because
Wait, but the source side.
All residuary matters are before.
This society election pertaining to a society.
Society, the society registration is the lordship's assignment.
1.1.
Election matter or a society.
entry 12 in my determination is writ petitions under Societies Registration Act.
Yes, ma'am.
This is writ petition under Societies Registration Act.
The body to which election is being sought is a society registered under societies registered.
Basically, my entire issue is pertaining to election.
Upon the amendment,
Election has a different.
Memorandum of that society itself.
Yes, Mr. Nanda.
I said they are relying also on the terms of the memorandum and article itself under the Society Registration Act, under which the society is registered. Because I am appearing for OCA.
But the prayer, my lord, if my lord will look at the prayer is to conduct election.
That
is specifically the prayer.
By two different coordinate.
Conduct the election.
Coordinate means.
Because the election has not been conducted.
The registration act.
And the term is over.
They say that under the act, it is the registrar who is competent.
And the term is over.
Only the civil code.
And the term is over. So therefore, the writ petition is the forum, my lord. Writ court is the forum.
No.
I'll place that Supreme Court judgment, my lord.
All right.
I'll place that Supreme Court judgment in this very matter, my lord, BCCI matter.
It doesn't matter.
And BCCI and all participant state associations, it covered. Because they are discharging public duty, the Supreme Court has held that all these issues can be adjudicated in a writ petition.
No, my lord.
It's beyond.
My lord, my lord.
Mr. Patnaik, according to you, this is a residuary matter.
My lord, no. I am saying it's in the prayer they say it's an election of a society, but society is the main contention whether a writ is maintainable against.
Are you arguing against BCCI's interest or
No. Don't tell me how to argue.
Please, just let us
Please bear with me.
No, please, please don't.
Please let me see if.
Vaccinate for a moment, look at section 11A of the society register.
Assignment, my lord, kindly see the prayer.
11 of A of the society registration.
No, because one thing is very evident, because it is not after being placed before Honorable Justice Rautray. I don't think Justice Rautray has recused.
No, yeah.
And it has not been placed before the Honorable Chief Justice, Master of the Roster, for assignment. But still it has been
accused.
no. So that is what I was looking at.
No, man.
Sorry, the recused is not the right word. But there is no observation regarding jurisdiction.
Take it out of my
Yes. So that way.
listed before the roster bench. That was the only observation.
Acha, para 6 you are referring. Oh, I missed that line. List this matter before the appropriate roster bench.
Roster bench.
That is probably what prompted.
Mr. Ashok Mohanty, senior advocate. Appears on behalf of the opposite parties.
Along with Jadipal.
Jadipal 5, sir.
Opposite pattern number 5 with.
5. Vice President, Odisha Cricket Association. Mr. Patnaik,
My lord,
Abhijit Patnaik,
OP number 2, my lord.
Lord Council submits that he has instructions to appear
My lord, I am filing
on
OP
behalf
number.
of the OP number 2, BCCI.
My lord.
Any other appearances? To
My lord, we are appearing for
Mr.
OCA, Orissa Cricket Association.
DP
We have
Nanda.
already appeared.
Senior Counsel, submit, along with Mr. A. Acharya.
A. Acharya or Mr. D. Nanda, whatever subject your lordship, sir. Mr. Nanda is there in the court, so your lordship.
Mr. D. Nanda.
Yes, ma'am.
Mr. D. Nanda along with Mr. A. Acharya. ସେଟା କଣ instructing counsel ଙ୍କ ନାଁ ଆପଣ କଣ ତାଙ୍କ ନାଁଟା ମତେ କଣ ଦେଖୁଛ so DP Nanda senior advocate along with Mr. D. Nanda and A. Acharya for Odisha Cricket Association
OP3.
It is submitted by the learned senior counsel Mr. Mukherjee, Mr. Palit, that earlier the matter was taken up before the coordinate bench by order dated 24.03.2026 by the said order at paragraph 6. Observation has been made thus. Quote kar diyo, para 6 step. Para. Apparently, because of the observations of the coordinate bench, as noted above, the matter has been listed today before this bench. Stop. Entry 12 in the list of determination of this court indicates within double quotation to single quotation to read petitions under Societies Registration Act. Full stop. Opens. You are seeking. Is there any interim prayer, Mr. Mukherjee?
No, I have an interim prayer, my lord.
Yes, I'm sorry, Mr. Palit.
I have an interim prayer. No,
I don't know why today I'm only saying Mr. Mukherjee. I don't know. You have cast a spell, actually.
Yes. So, my lord, I am only praying for my lord.
How can the
IA.
taking election? How can that be an
Exactly.
interim?
No, the interim prayer. Interim prayer.
What interim prayer?
IA 5251
Yes.
of 26. No coercive action to be taken against the petitioner number 1 and 2 of the claim.
By the coercive action to be taken by the
OP1. OP, my lord's.
state.
OCA, yes. OCA.
Cause of action.
OCA.
It has nothing to do with the
I
petition.
think that way.
No, this issue is-
Yes, coercive action. I think it can be contemplated also under Society Registration Act.
They can't, it will be a void order because in any event, my lord, the term is over. The body is continuing without any mandate.
Anyway, so I mean that is not that significant to be considered right now. It will be. Yes.
It will
Copies of adequate number of copies shall be served on the all learned council on record. And also who wish to file their respective wakalatnamas. Caveat has been served. Copy.
Everybody has.
I've been
Then next para. Copy of the application has been served on the learned counsel for the caveator, Mr. Misra. So Mr. for the caveator, the caveat stands discharged.
No, sir.
Yes.
I have entered appeals for OP number 7 Milos. Today I have entered appeals.
Mr.
So I request my friend to give a copy of the.
Okay. Appearance actually proves that. तो by insert कर देंगे. वो prove हुआ दरकार नहीं. जोठिले लेखन तो से साइड रे लेखन तो नहीं गए. दिन लेखन तो.
7 appear करते.
आपण जेतेबेले साइड रे लेखिबे ठीक खबर नहीं आपनकर जो मार्किंग गुडा. गोटे स्टार मार्क लेखन. Mr. L. Samantrayal under senior counsel submits that he has instructions to appear on behalf of.
No, but today I am filing my appearance memo. Milos.
Correct. He has instructions to appear.
7 Milos.
On behalf of OP number 7. Along with instructing counsel, Mr.
Mukesh Mahan.
Mukesh Milos. So also say
Mukesh Mohan.
Mahanti. Mahana.
Mukesh Mahanand Milos.
Mr. Mukesh Mahananda. OP number 7. The J. Samantrayal and Mr. J. Samantrayal. J. Samantrayal.
Copy will be served in course of the
Yes.
day.
এটা রইলা তো এটি লিখিবে তারপরে again কপি সার্ভিস সব লিখিলে তো না কোন লেখাই পড়ো ক্যাভিটেটা ডিসচার্জ হয়ে গেল বাকি কপি সলভ করাতে অনেক লাইন লিখিছেন copy of the writ application along with IA and other connected papers shall be served on the all learned counsel appearing for the opposite parties during course of the day.
During course of
During 2 working days. By tomorrow also.
others who had appeared on the last date, we have already served.
I mean, I'm not specifying that.
Only Mr. Samantra is to be served. His office is to be served.
Within 2 working days, it is submitted by the learned senior counsel, learned instructing counsel for the petitioner that some of the learned counsel have been already served pursuant to the listing on the last date. Stop. The Mokaratnama and appearance memos of the learned senior counsel appearing for the opposite parties shall be taken on record. Scanned copy be updated. The name of the learned counsel shall be indicated in the cause list as well as the case brief from the next listing. The matter shall be listed for orders. ଆପଣ କେବେ ଚାହୁଁଛନ୍ତି ସଜେଷ୍ଟେଡ ଡେଟ୍
ଏ ୱିକ୍ ରେ ଆଉ ନାହିଁ
ଏ ୱିକ୍ ରେ
Next week.
sir next week में छुट्टी तो पड़ी जाएगा तो ता पर सप्ताह रे निडे एस्टिमेट
ଆଜି ହେଉଛି I mean all the seniors kindly agree for a date.
Week commencing 6th April.
Not 6, my lord. Let it be on 13th. Right? 13th.
no it will 13
On consent of the learned counsel for the parties, the matter shall be listed in the week commencing 13/4/2026.
Okay, Lordship, I was only suggesting 6 because of the urgency, my lords.
No, nothing will happen.
Before the end of the year.
Nothing is, I mean, coercive action, in fact, it's very difficult to contemplate.
Coercive action, lords, not coercive action. The main issue may be addressed by the main issue. Whether selection is to be held or not.
So then I think pleadings should be completed.
Yes, right. Yes, right.
So take more time. So that at least the battle lines are drawn. You are served with the copies of the pleadings.
My lords.
So list in the week commencing 27.
27 ने मेरे
27. नहीं ଗୋଟେ ସେକେଣ୍ଡ
आगे
27 ତାହେଲେ ତ ନେକ୍ସଟ ୱିକ୍ ରେ ହେଇପାରିବ
ଆଜ୍ଞା
କାରଣ ଆପଣ କାଉଣ୍ଟର ଫାଇଲ କରିପାରିବେନି 27 ସୁଦ୍ଧା
डिफिकल्ट देखिए
Can we not have
काउंटर देखिए फाइल
week commencing 20?
counter complete kar the pleadings. I am asking the opposite parties to complete the pleadings by serve it on say 24th.
Let it be, if there is any difficulties, then
The pleadings shall be completed. Pleadings on behalf of the opposite parties shall be completed upon serving copy thereof by 20 na 24 by 24/4/2026. List in the week commencing 27/4/2026.
No, no.
Yes.
let it be.
most of our
28 କାଳେ 27 ଛୁଟି ହେଇଯାଇପାରେ ପୁଣି
actually, in fact, that is the reason I am trying to make it
I'll have an alternative prayer, my lords. I'll have an let it be placed for orders. Both the IAs be taken up on.
No, that the orders I am not changing. I am not saying for admission. I am requesting simply.
No, in the let the matter come for orders.
It will be. I have already directed for orders.
Orders, my lords, week commencing 6th.
No point. It will be, I mean, churning without much material.
Let's have it, my lords. Let's have the day.
You complete the pleadings, liberty to mention. Any that last line, from any urgency, I am giving you liberty to mention.
My prayer for your lordship is let's have it. Lordship may give some time to this, and then your lordship may decide.
No, but it is better to be. This will be highly contested. If I think it will be easier for the petitioner also to, I mean, know where he stands if the pleadings are completed. So liberty to mention is always there. कौन लिखले 24 सुधा देबे 27 रे लिस्ट करिवे. I am saying we commencing.
Yes, sir.
We commencing, so it will be adjusted.
Right.
One of the reasons being making it we commencing is that if a day is not functioning or I am not available, then it can be adjusted. Otherwise, it gets stuck.
Let the miscases be kept open.
All are kept.
Let the IAs be kept open.
No observation because they will be filing their pleadings. Including have option to file to the IAs also.
But IAs be kept open. Liberty to mention.
All are. Everything is kept open. Nothing.
Liberty to file further, I guess.
पूर्व लाइन था ना. Upon serving copy thereof on the learned instructing counsel for the petitioner, pleadings in the writ petition as well as the IAS कर दियो. Pleadings in the writ petition as well as the IAS shall be completed by 24/4/2026 upon serving copy thereof on the learned instructing counsel for the petitioner. तापरे लेखन्तु list in the week commencing 27/4/2026. Liberty to mention.
They will mention the IAs.
All everything. Read can be mentioned.
Further,
Order ta bhuli. Say the court master points out a mistake, typographical mistake in the order. So kindly listen. Se kon koche code a bhule chi kone. It is for the petitioner actually. Petitioner kode bole. No. Se code koche order bhule. The order number should be 1. That's found out by the suggested the list has likha hai.
It is already an order.
The registry has pointed out a typographical error.
Order number should be 2, my lord. All proprietary.
That is also a judicial order.
That was an order by the first bench. So
Order number 1 hobo na.
2 hours.
2 hobo. Lokunanti dekhantu.
2 hours.
Dekhi diyantu. It is there in front of you.
ସେଇଟା order number 2 ନାଇଁ ଏଇଟା
ସେଟା 2 ଲେଖା ହେଇଯାଇଛି.
ନାଇଁ
no, there was a
ଏଇଟା
order number 2 ଲେଖା ହେଇଛି.
2 ଲେଖା ହେଇଯାଇଛି.
The registry has pointed out, the process points out, I think the corrections can be done by the roster bench, na session bench. Se jo seti jo.
ସେଇଟା order number 2 ବୋଲି
ସେଟା change ହେଇଯାଇଛି. ଆଗରୁ correction ଗୁଡା ଯାଉଥିଲା ମାନେ the judge, but now it is the roster bench. The registry has pointed out yes.
ଆଜିଟା 2 ହବ ସେଇଟା 1 ହବ.
Registry has pointed out inadvertent typographical error that has crept into the order dated 24/3/2026. The order number shall be read as order number 1. Accordingly, the today's order shall be order number 2. Eta upara sabha upare introductory paragraph karti. First line. Yes. Next.
11.
Case minors one SSG group.
Mr. Dayananda Mahapatra, Senior Counsel, along with Mr. Arya Das for the petitioner, Mr. Prabhu Prasanna Behra, the opposite party, additional standing counsel. Yes, Mr. Mahapatra.
One petition was SSG group minors was given minors the responsibility of minors distribution of PDS rice mill.
these PDS rise matters, there is an allegation, the allegation mostly technical allegations. That allegation is a matter matters kind of a glance to a report, and that is at page matters 13, 115 matter. Basing upon this report, the whole total allegation matters may summarize it in that way that they have not displayed the board concerning the price, the quality of rice, technicals, all are technical points. It's not that there is no allegation that I pilferage, there is a pilferage and all these things, excepting one very pertinent allegation that yes, these were kept in different places. That is what SSG group minors has given an explanation that because of the vast area and because of the fact that these people nowadays minors, they are demanding that it should be supplied in my house also. That is why we kept in different places minors for our convenience. But there is no allegation whatsoever about any pilferage. But that is what very important. Miles knows that
you have come to at the level of so-called.
Yes. No, Miles, we have come at after that. The order was,
just 1 second. In any case, the liquid appearance memo of the senior counsel, Mr. Mahapatra, shall be taken on record. Scanned copy be updated.
But thereafter, Miles, my license was suspended.
Yes.
Miles, after suspension, I have come before the Honorable. That is at page 18.
But that proceeding before the ADM?
ADM, that's proceeding before the collector.
Here it is collector.
Yes, proceeding before the collector. That is very pertinent, minors. My very specific case is that, minors, how my scope of reasonable opportunity are taken away. That's searching for that PDS control order, minors.
That provision where you can challenge this order.
Minors, appeal, minors. So this is that 19 of the PDS control order.
PDS control order को मसिया
2016
ठीक अछि मोबाइल अछि आपण देखो 2016
so we prefer appeal. Person to the direction of the Hon'Ble High Court, go and prefer appeal, and we prefer appeal minors.
केते नंबर
2016 it's order number 19.
Order 19. Correct. Yes.
Minors.
आपनकर सस्पेंशन डाक देखो प्लेस करंतु
suspension minors, that is it.
17 18
Minors, page 16.
Provision.
Suspension order.
Provision. ସେମାନେ କୋଉଟାକୁ restore କର ମାନେ they have sought the recourse of which provision to suspend it.
Yeah. Kind of class 2 17
10(1) GMQ.
सेटा तो कंडीशन 10(1) G and Q टा होची आपनकर जो परमिशन
violation
70 कंडीशन टा 17 minors. No, it is not related to suspension, no. Suspension. It's 17.
One G and Q. Yes.
Nurse.
ମାନେ 10(1) ସେଟା ହେଲା ଆପଣ ଭାয়োଲେଟ୍ କଲେ ସସ୍ପେନ୍ସନ ପାୱାର ଟା ଅଛି 17
suspension power generally manner they exercise that power on 17. Yes.
The licensing authority may by order without giving prior notice to the dealer suspend the license of a dealer.
Yes.
If a proceeding under such clause 1 has been initiated
Against the dealer.
Yes.
And the said licensing authority is satisfied that it is not in the interest of the smooth operation of the public distribution to allow the dealer to handle the PDS again. That is restored.
Then you file 19(1) appeal.
That order was the impugned order is at annex at page 16.
The 16 is the suspension order.
Suspension order. Yes. That portion. Suspended with immediate effect. Therefore, the PTS license granted in favor of such persons is hereby suspended with
They
immediate
don't refer to actually any provision, but anyway, apparently 17th. Okay.
So presumed it is 74.
I mean, power is not disputed.
No power must be cannot.
Power not disputed.
There,
Okay.
my lord.
Power is there. Okay.
So
Yes.
that is how we have come before the Hon'Ble High Court. In WPC number 22529 of 2025, my lords.
Yes.
Thereafter, Hon'Ble High Court directed no, there is an appeal provision. Go
19.
for appeal.
Go in 19. 19 order.
19 order. My lords,
Page 23.
Now, page 20, that first order, my lord, kindly have a glance to page
Notice, Mr.
26.
So Mahapatra, take notice. Because you are challenging a statutory order.
No, my lords, I am on a very simple point, if my lords will be pleased to consider.
No, without notice, how can I?
Notice, my lords, that is there, my lords.
Interim prayer for?
Interim prayer, my lords, so to stay the impugned order, my lords.
No. Then final prayer.
But here in this case, I do say stay the suspension order. Because of the fact that I'm coming to that. If my lords permit me 1 minute time. Kindly have a glance to page 26. Why I say so? My case is that a reasonable opportunity may be given to me. It can be remanded also to the collector to hear the matter and can dispose it of. Kindly have a glance.
Suppose, I mean, for what you are seeking, a remand order you are seeking,
Yes.
that Mr. Behera has to agree. Prabhu has to agree. Unless Prabhu agrees, I can't pass.
He is very reasonable and rational.
But him after instruction, I am not passing any order.
It's that, but it's only one line.
Give him some time. You have to be reasonable also.
Agreeable to that.
Because a petitioner seeking opportunity of hearing before the authority should also expect opportunity of hearing to the other side.
Yeah.
So let us grant them that
I
opportunity.
can dispute on that. Only may small prayer minutes. 31st minutes the last date minutes because my period is going to over, then I am to apply for the renewal. May I be permitted to apply for the renewal minutes?
But what can be done?
My application
The
may be taken out.
consequences is not stayed. So suppose you are applying, then what would be the consequences have not been stayed.
No.
So you have to address the court that what is the consequence of this order at page 23.
Obviously, suspension order continues, my lords, because they say that a new person would be
So
appointed.
then if in that case, how would before decision, how it can be allowed?
That is what exactly, my lords, I appeal
Is
to.
there any provision? First of all, any legal provision?
My lords, I am coming. Kindly bear with me 1 minute. What my humble contention is, there was a stay order by the appellate authority. That is at page 26. Kindly have a glance to that, page 26, the stay. Thereafter, what happened? But thereafter, what happened, my lords? Sorry, my lords, page 28. Status that the court passed an order, but the appellate authority, I am inclined to direct that the order of the sub-collector Kendrapada against which this appeal is preferred shall not be taken effect till the disposal of the appeal. That is the order pending disposal of the appeal. That is the order interim order I seek before my lords. Then my lords, what happened? Let us go a step forward. That continued. All of a sudden, my lords, the case was predated to 11/2/2026, requiring me to appear. By that time, my lords have given a direction, my lords direction, that is at page 36. That is up to 17.2, my lords, this order to be, the learned AGA shall intimate the authority not to proceed in any manner for hearing of the matter till 17th. Anyway, my lords, now what happened? After 11th, my lords, this case was put up on orders to 25th. And 25th, the final order was passed. On the date I requested, my lords, I don't know.
This since I remember the facts also,
Yes.
I have some difficulty in forgetting.
Yes.
So let Mr. Prabhu justify that. Because again, it was argued by Mr. Siddharth Misra. So he says that he argued, in fact, by the time that though it was specifically directed the order dated 13/2/2026. So then you examine that whether 13.2 has been complied or not. 13.2 order.
13/2.
Not 13 Hindu Marriage Act. Because you are always sitting in this, this is a admixture of all jurisdiction. So 13.2, then if you can justify that 13.2 has been satisfied.
Well, that I have to verify.
No, because this is the way you can make your order beneficial to the apparent the person who is at the receiving end. By not simply making some technical flaw, and when there is a High Court order, you violate. I cannot go, I cannot get out of that 13 order passed by me.
Certainly, yes.
So you must understand the limitation also there.
Yes.
Yes. So when do you want?
Because considering my learned senior's submission minutes, I'll try to get it as soon as possible. Then we'll do your lordship.
No, he confines into that after 13 order also, it was not been complied with.
That limited question
Yes.
yes.
And undue haste for so many reasons, at times the authorities so undue haste.
That exactly. It happens, my lord. So nowadays, my lord, this is the biggest field of medical operation.
It had been always there.
It has been always there.
The lawyers will be idle also. Yes. Hard on it. The petitioner, a self-help group, petitioner self-help group. Represented through its secretary. Women's self-help group. Women's self-help group. Into bracket, all capital, WSHG, bracket closed. The petitioner women's self-help group represented through its secretary is before this court challenging the order dated
Order dated by Lord 25. That is at page 32, page 25 too.
Index पढ़ेंगे सेटा anyway. Undated collector district magistrate.
25/2/2026 page 32 minors.
जड़ा पड़ुची 25/2/2026 25/2/2026
8608 8690. No, 8690. Check.
Passed by the collector Indrapada.
Yes.
In PDS, all capital, PDS appeal number 02 of 2025. It is submitted by the senior counsel that during pendency of the appeal, the petitioner had earlier approached by filing WPC number 24202026. Wherein no stop for the 2026 stop. In the said writ application, after hearing the learned counsel for the petitioner as well as the learned AG, the following order was passed. Paragraph 3 of 4, page 36, Raj. Before quote कर देना. Stop. He submitted that the order dated 13/2/2026 was not complied with, followed by the authority while dealing with the matter under section 19, under order 9, order 19, ORDER, order 19 of the Odisha, PDS, into bracket control, bracket closed, order, 2016. Stop. It is submitted that such action of the authorities vitiates the order. Stop. The records of the disposed of writ application, WPC number 2420 of 2026 shall be placed along with the present writ application for reference. Stop. Mr. Behra, today I'll issue notice or you will obtain instruction, then I'll deal with it.
I'll get instruction.
Okay. The additional standing counsel upon advance copy served appears and waives notice on behalf of the opposite party. All opposite parties, plural. He has adjournment to obtain instruction in response to the submissions made by the learned senior counsel for the petitioner. List in the week commencing? List under list for admission as well orders?
Admission yes.
List for admission?
Fresh admission.
Fresh admission. Orders as list for orders in the week commencing? 11/5 ହେଲା ଆପଣ ଜଲ୍ଦି ଦରକାର କହୁଛନ୍ତି ଜଲ୍ଦି କରନ୍ତୁ 4/5 ବିଷୟ କହୁଛନ୍ତି ତାଙ୍କର 31 ସରିଯିବ ଆଜି କାଲି ସରିଗଲା ସବୁ ଆର ବର୍ଷ ଆଉ ଥରେ ନେବେ ଆଉ
ନାଇଁ ସେଟା କଥା ପଡିନି କଥାଟା ଯଦି ନୂଆ କରିଦେଲେ ନା ଆମର ରିନ୍ୟୁଆଲ ରାଇଟ୍ ଟା କଟି ଯାଉଛି
ନାଇଁ ରିନ୍ୟୁଆଲ ରାଇଟ୍ କଟିବନି କାହିଁକି ଆପଣଙ୍କ ଅତି ବେଶୀରେ the 19 proceeding will be restored appeal will be restored
ରେଷ୍ଟୋର୍ଡ ହେଇଗଲେ ତ କିଛି ଅସୁବିଧା ନାହିଁ
ରେଷ୍ଟୋର୍ଡ ହେଲେ ଯାହା ହବ ଆଉ କଣ list in the week commencing upon keep Mr. Behra, you decide.
Within a week, I'll get.
And then minors may be taken up on 20th. Minors will commencing 20th. Or 13th minors, whichever will be.
30 तारीख. In the week commencing 13/4.
I'll get it positive.
Yes, yes. But it seems that they were made oblivious, I don't know. Because I think Mr. Lenka would have informed them. Yes. Anyway.
12 amendments, only small prayers. The same 12 months of the same case. May submit only small prayer matters. The collector must be in the appeal. Collector protected me. Interim order protected the interim. Well, given me the interim order. The same interim can I have prayer matters?
No, that would amount to the IA not the Purbo matter item 11.
Yes.
IA likhive copy the allotted additional standing counsel shall obtain instruction.
Only thing about protection of the collector's order matters. Collector given me an interim order. Matters I'm insisting it.
A read code should be better performing than a collector.
I don't dispute mine because
after the collector's final order, interim order has merged.
Yes.
So the read code must understand that also.
I'm not on that.
So I'm not because I'm not rejecting it. I'm not rejecting it. Let us wait.
That is lying over. That is lying over.
Yes.
Only thing I may press another prayer matters. So far as that the order of the collector to proceed for the fresh selection. That is matters because my right of renewal will go.
That you have to challenge in a separate proceeding.
Well, so here matters my humble
because right of renewal, whether you can, simultaneously both things can be possible. Once you challenge, you are successful. It will have some consequences.
Suppose suspension order goes and I succeed, then my right of renewal will be matters considered in merit matters. There is no problem. If I will be subjected to that,
but that is the inquiry right.
That is.
Because unless I give you guarantee that I'll allow the application,
that is subjective.
I cannot pass the subsequent order.
That is subjective matters. I understood that. Only thing is that matters in two way matters I may be protected. Either matters I may be permitted without prejudice to submit the application.
Yeah, I will look at any action taken subject to the any action taken pursuant to the advertisement code upon annex करचंदी.
Could I get to order that?
Advertisement.
आइए हाँ नोट तो सर पर order categorical लिखी दी चंदी page 34. The sub-collector Kendrapada is being licensing authority hereby directed to take steps.
Just 1 second, let me get that.
Yeah. Page 34. Last the sub-collector to paragraph 3.
The collector and district magistrate, while deciding the appeal, has directed thus. Quote कर देवे. Page 34 रे अच्छी. The interim order dated 26/11/25 in this appeal is vacated. तापर लिखिए the sub collector केंद्रापड़ा up to नहीं की disposed of chair. ये quote कर देवे. The counsel for the senior counsel submits that though the collector was dealing with the appeal in his case, but he has chosen to direct the sub collector for appointment of new retailer. एटा मिस्टर बेहरा केमती होबो?
सेटा सस्पेंशन टाको चैलेंज हेतला.
एटा न्यू जुरिस्प्रुडेंस होते अलगा प्रकार. माने एडमिनिस्ट्रेटिव एक्शन रे आपण गोटे जिंस टाको अपील डील करचोंती. आपण ता धिरे भर्ती कर देलेनी आ गोटे जिंस आनी की
for appointment of new.
So that is how truth cannot be hidden actually. Truth has this power to surface. କଣ ଲେଖିଲେ? ନାଇଁ ନାଇଁ ସେ ଆପଣ ଯୋଉଟା ଇଂଲିଶ କହୁଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି ଟିକେ ଆଉ ଥରେ କୁହନ୍ତୁ। He has ଆଚ୍ଛା for reasons best known to him the authority for ସେଇଠି ଯୋଉ ଇନସର୍ଟ କରନ୍ତୁ ନହେଲେ ପୁରା କାଟି ଦିଅନ୍ତୁ କୋଉଠି ଆପଣ ସରିଲା ମତେ କୁହନ୍ତୁ ଆଉ ଥରେ ଡାକିଦେବି କନଫ୍ୟୁଜନ ହେଇଗଲା ଏଇଟା କଣ ସେଣ୍ଟେନ୍ସ ଆରମ୍ଭ ହଉଛି ବଟ୍ appeal ସେଟା କାଟି ଲେଖନ୍ତୁ appeal ତାପରେ କାଟି ଦିଅନ୍ତୁ appeal filed by the petitioner under section 19 of the OPDS into bracket control order 2016 comma for the reasons best known he has also passed orders in the appeal order directing to take steps for appointment of new retailer according to the conditions of the OPDS control order 2016 for larger public interest. Stop. Prima facie, the submission of the learned senior counsel regarding the authority choosing to pass orders regarding appointment of another dealer in a proceeding under section 19.
Challenging order of suspension.
Challenging order of suspension. Cannot be countenanced. Stop. The learned additional standing counsel shall also obtain instruction whether regarding appointment of the new retailer was dealt with any other file. Stop. The records shall be produced for perusal. The records of the file regarding the records of the appeal proceeding, it's the number tab dash, as well as the records pertaining to the opening of the new retailer according to the conditions of the OPDS control order shall be placed through the learned additional standing counsel for consideration of this court. Yes. Next story. Second टा ना प्रथम टा को ठीक है Mr.
The second one,
Mr. 12 रे Mr. Dayananda Mahapatra senior counsel along with Mr. Arya Das for the petitioner 8714. Mr. Prabhu Prasanna Behra additional standing counsel for the opposite parties. Same order habo kari paribe?
Same sir.
Same order. Identical order kar do. Ethire भी share करचंदी. Appointment of fee.
Yes, 29. Same order, not same organization, same order.
Ponte 19 टा देखिए Mr. Das, Mr. Arya Das. देखिए 19 रे सेमती किछि अछि कि ते appeal consider कला बेले से अन्य जिंस भी करि परिबे.
माने plenary power.
हमर माने बेसिकली हमर जेति कि judicial power अछि we cannot exercise.
No. 226 that is an exception.
226 करिबन.
Take limited to that limited some
unless PIL. PIL रे आपण
that exactly what my lord
PIL concept is diffused social interest. PIL is not an individual right. But suppose I am dealing with an appeal, so whether I can
concerning that order, yes or no, but cannot be on a third order judicial part.
That's a new thing. Common sense as well as whatever little I have understood or read,
rightly, my lord, this is the fundamental judicial process, my lord.
19.5 only talks about
19.5
stay of that impugned order, that much he can do.
That exactly he has done.
That in fact, the 19.5 many cases they are seeking a direction that the collector should pass 19.5 order, and in this case, collector has passed 19.5 order.
While vacating further, he could not have.
Because then 19.5, what is the nature of 19 proceeding?
Yes.
19 proceeding is not an administrative proceeding for appointment of dealer. I think that would be a the other part is that you have to find out under which provision, which order rather, the dealer is appointed.
Yes.
Yes. Yes.
That would be power, most likely.
Nice.
Item 13.
No, please, your lordship.
Mr. Sitam Kumar Naik for the petitioner. Prabhu Prasanna Bera.
No, your lordship.
Mr. Ansuman Sethi for the opposite party. Yes.
Lordship, I'm praying for Lordship be kind enough to administration to activate the Hadmar ID card, your Lordship, which has been deactivated due to the wrong updation of ROR only.
No, this is for getting PDS or selling paddy.
Selling your paddy, your Lordship.
Selling paddy is not my jurisdiction. That is not my determination. Selling paddy is there.
The petition is procurement for the paddy, Lordship.
Procurement is not there in my. So, in fact, it is there. I think it is residuary. Mr. Lenka is not today. Then you can ask Mr. Lenka. Mr. Lenka found out that a coup portrait achi procurement. RMC, Regulated Market Committee. Procurement is by the RMC or residuary. If RMC not then residuary rejivo. Authority case, Mr. Naik? Who is the authority?
Civil procurement, Lordship, civil supplies. Lordship, opposite party number 4, Lordship, civil supplies procurement authorities.
There is one that is called Justice Sasikanta Mr. Inaction of revenue authority judge is there. ଆପଣଙ୍କର ମନେ ଅଛି କି? 16 देखो जस्टिस बेहरा एंट्री 16 Read petition relating to Odisha Agriculture Produce Markets Act.
Agriculture produce market, yes.
I think Mr. The petitioner has approached this court challenging. ଆପଣ କଣ apply କରିଥିଲେ ନା ନାଇଁ କଣ?
Lordship applied, but due to the wrong operation of ROR, they have cancelled or deactivated our farmer.
Challenging cancellation of petitioner's farmer ID card. By the authorities, by the authority, particularly OP number 4, stop. The petitioner claims to be a small farmer and seeks for purchase of paddy. Purchase of paddy from him by receiving minimum support price. Stop. The subject matter is not within the determination of this bench. Stop. The matter shall be listed before the matter shall be placed. The registry shall do the needful for placing the matter before the assigned bench. हब ना आ गोटे अच्छी इनएक्शन बाय द रेवेन्यू अथॉरिटीज पर आपनकर अथॉरिटी होचंती तहसीलदार एंड आरआई बोथ आर रेवेन्यू अथॉरिटीज देयर इज अ स्पेसिफिक असाइनमेंट read petition relating to inaction of revenue authorities. Yes, next. That is court number 12. Court number 12 रो अछि आ गोटे अछि आपनकर कोर्ट नंबर 21.
So item 14 is also same.
Same order.
Obliged.
Mr. Ansuman Sethi लिखते. Yes, next.
15 my lord, on Mr. Sarada Prasad Das can taken up one gift from it.
Your name, sir?
Bibu Prasad Charles.
Mr. Bibu Prasad?
Chwal Singh.
Roy.
Chwal Singh.
Chwal Singh. Mr. Bibu Prasad BP Chwal Singh. CHUALASILGH. On behalf of SP Das for the petitioner. Adjournment is sought for on behalf of the learned counsel for the petitioner. On personal grounds. The matter shall be listed in the week commencing 27/4/2026.
Obliged.
Stay for fresh admission. Password back to you too.
Password item 3.
None appears for the petitioner, though the matter is called twice over. Once when it reached, and thereafter, once when it reached, then comma, again after about an hour. Stop. None had appeared when the matter was last listed on 9/3/2026. Stop. Prior to listing on 9/3/2026, 9.03, 9 March 2026, the matter was never listed, though presented before this court on 24/4/2023. Stop. On now we commencing कर देबे.
वो commence.
केबे करिए 20 ना कितने
27.
20 रखना है कि आज कितने लोग shall be listed in the week commencing आज 30 नहीं 13/4/2026, indicating that the matter shall be disposed of Stop. Copy of this order along with the next date of listing shall be intimated to the learned counsel for the petitioners by the registry. Stop. Next, Karo.
That's our item 5.
None appears for the petitioner, though the matter is called twice over. Stop. Once when it reached, stop, no, comma. Once when it reached, and again after about an hour later. Stop. Then stop. The matter was earlier listed on 17/3/2024, was heard at length, and the issues involved were noted by the said order dated 17/3/2024. Heard at length, heard at some length probably. Stop. To grant further opportunity to the petitioner, the matter shall be listed in the week commencing 26 କହୁଛନ୍ତି ନା 27/4/2024 27 ରେ ଫେର ଛୁଟି ଅଛି ठीक है so we commencing 27/4/2024 copy of this order as well as the next date of listing shall be intimated to the learned counsel for the petitioner by the registry. Yes, next.
That's our item 6.
So Surendra Kumar Vishwal for the petitioner. Yes, please.
Petitioner filed this case against the interim maintenance matter passed by Lawrence Family Court, Baleswar. And
yes, it has been heard at length, Mr. On 11/2.
Yes,
you have to take a legal stand.
Yes.
Vishwal, the difficulty for the court or for the lawyer is that they are they are talking in terms of the law. So the person doesn't want to pay. We are not here to support him. The bound to pay.
Adjournment.
The same date. The legal is sufficient to pay. You are not asked for the submission for instruction. You get the advantage for the process. It's for the assignment. According to the understanding, you say the week coming see.
कन्फर्म 27 है
Please check the details.
Passover item 7.
Appears for the petitioner normally likely for 5 to 1. Once when it is. And again. After. For 11 years. The matter was heard straight from 30.01 of the due cases. The legal issues were will say the counsel for the which adjournment to have this the legal issue. Thereafter, the matter was listed on completely service. Adjournment was not one. We have a petitioner. We have a and the matter action and within 3026, the matter was actual accidents of the following order was passed. And further opportunity to the petitioner.
Zero child.
Zero child, 2 service. The copy of this order, as well as the release date of streets have been indicated to the right pass for the
Petitioner by the registry. Stop. Yes. Call Karantu.
Item 16.
Mr. B.S. Panigrahi for the petitioner.
May please, Lords.
Yes.
Similar the matter relating to custody of the minor child.
Yes.
The appellants are the father and the paternal grandparents of the minor child, Miller.
Age?
Age, Miller, at present, the minor child is of 14 years, Miller.
So you had sought for custody.
Yes.
Now the mother died.
The maternal grandparents, they sought for custody. The mother died and the allegation of dowry death against the present petitioners, the husband and the in-laws, Miller. And there is also conviction for the offense on section 304B and 34 of the IPC and 4 DP Act, Miller. And the petitioners are on bail by this Hon'Ble Court in criminal appeal.
This you argued on the other day.
Yes, Miller. You Lord,
so I had asked you this question.
Yes.
That being impatient after being convicted for death of the mother of the child, you are impatient to get the custody of the child. And the problem is now what would be the environment for the child if a child aged about 14 years has to believe the court?
Yes.
Has to believe the court. Let us assume he doesn't believe the court. conviction order, he doesn't believe. Still, he will have a perception also.
Yes, my lord.
Because he stays with the maternal family. So they will be telling him they are the murderers. So this is you should be patient with your approach.
My lord, two questions you lords asked me to clarify. This is one of the question. And therefore, so far as custody of the minor child is concerned, I don't want custody of the child because now it's 14 years age. After 4 years, he will be major. The second question your lordship asked me with regard to the visiting right, my lord.
Whether you sought for, you are not sure.
Yes.
That day, whether you sought for vegetation and
I was
contact
not
rights.
sure. I was not sure, but I requested for the entire order sheet. The order sheet shows that there was an application was filed for visiting right, and the learned court will also directed for production of the child on repeated directions. The child was once produced when the father was produced before the court for his examination. The child was produced, and there was also interaction between the father and the child. So since the
so what order was passed or what order you sought for after production of the child?
My lord.
Did you seek for any order of visitation and contact?
No, my lord, that petition was interim application was filed.
No.
The final judgment,
from your tenor of your submission, it appears
my lord,
you never pursued that application.
No, my lord, I pursued that application and
the result
repeated direction was issued.
No, after that, sir, again you are rewinding the clock. ଆପଣ ଗଲେ ଯାଇକି application file କଲେ, ବର୍ତ୍ତମାନ ଯାଇକି ପହଞ୍ଚି ଗଲେଣି repeated order ହେଲା, ସେ appear କଲା ଛୁଆ.
ଆଜ୍ଞା.
ତାପରେ କଣ ହେଲା ଆପଣ ଫେର ପଛକୁ ବୁଲି ଯାଉଛନ୍ତି ଆଉ ଥରେ.
ତାପରେ ଜଜମେଣ୍ଟ ହେଇଗଲା.
ଆଉ ତାହେଲେ ଆପଣ ପ୍ରେସ୍ କରିନାହାନ୍ତି.
ତାପରେ ଜଜମେଣ୍ଟ ହେଇଗଲା and judgment ଆଉ visitation right ଉପରେ କିଛି discussion କଲେନି. Therefore
ଆପଣ ପ୍ରେସ୍ କରିନାହାନ୍ତି ଆଉ. The problem is most likely, I think you do, because the lawyer who was conducting counsel before the learned trial court had a purpose. Suppose the child would have recorded when he appeared before the court, how old was he? 12 ବର୍ଷ ଖଣ୍ଡେ ହେଇଥିବ ତାକୁ.
ଆଜ୍ଞା.
କେତେ ଅର୍ଡରଟା?
It's 2017 million.
17 ହେଲେ 7 ବର୍ଷର ଛୁଆ. ଏବେ କେତେ ବର୍ଷ ତାକୁ?
ଏବେ 14 ବର୍ଷ.
Date of birth?
Date of birth 2012 million.
14 ବର୍ଷ. So it's most likely say that the child did not say good things about the father.
But
so as a prudent counsel,
yes.
So you may not win the case, but don't spoil your future case. So that is how it was not pressed. So you may have the second chance of approaching for.
Yes, that your lordship was also.
Are you sure that you are? Right now you are not pursuing this appeal.
But to that extent, for filing application for visitation right, your lordship remand the matter back for.
No, remand. I have to decide with on merit whether being convicted of killing somebody's mother, the custody has to be handed over to the because even allegations.
Yes.
The West Bengal case.
Well,
in West Bengal case, the allegation is enough, and. In one case, the custody has been granted to a foreign national. There is an allegation against committing murder of another person in that country.
Yes, ma'am.
That is a different thing. He's a rich person, so the 1 crore was directed by the Supreme Court to be paid. So here the facts are very.
It's
if you check that decision of. Because one division bench decision of this court, Justice Vishwanath Ratha and me, we have rendered. There we have referred to those decisions because in that case, we have not granted the father, but we have only observed that gradually there will be contact between the child and there is no determination who had killed the mother.
Yes.
Mother died, no case, no criminal case. The daughter stayed with Mamu and I.
Yes.
Correct. Then they sought for custody, and in that case we interacted with the child. The child was very happy and to stay with maternal parents. So at least for the benefit of the child, she stays with 2 of her siblings. Cousins. Mamu jhiyo, bhoni ki bhai. So se jagare hele bhi it becomes more difficult to displace the child from the custody, though there is no allegation. Allegation was there, but they entered into a compromise kind of thing. Certain properties were named in the name of the child, and that was the person again remarried again, and they wanted that the child should come
I
back.
have gone through that judgment, Your Lordship.
Achha. Can you give the reference?
Just now I can
Okay.
give back.
I'll find it out. So there we have referred to that decision where, so in West Bengal case, Supreme Court did not grant. If you take instruction whether you'll pursue the appeal, because appeal, I think it will not will be going against you.
It will go against me.
Because after conviction, only the learned judge family court has thought about not granting you. But obviously, I mean, you can have contact and visitation rights.
Well, by the time this judgment was passed, there was no.
You talk to that lawyer, then you know the facts. What the child stated. I think that is how the case was saved by the lawyer.
Yes.
So he purposefully did not place the visitation and contact right because the child would have said so many things.
But I was interacting with the father, but he said that there was very good interaction between the father and the child.
With time, he may start the relationship between the father, his in-laws, is very difficult.
At that point of time, he was 7 years. He also, as I interacted with the father.
So he should be thankful to. He should be thankful. The person should be thankful to his in-laws if they have allowed and they have not said anything bad about the father, because he is convicted. Law has held him guilty. Due process of law has been followed. He has been found guilty. So that shows is one a positive sign that in future he may have access to the child. These are very delicate things, as you understand, Mr. Pading. Very, very delicate.
In the meantime, since 4 years left and the child to become major 18 years. So in the meantime, if there will be interaction, then the relation will develop. That is the only aspect. Otherwise, this custody part.
In any of the orders, the child statement has been recorded?
No. Child statement was not recorded. He was also not interacted by the court. He was only produced to be interacted with the father in the court.
So what do you want today? Adjournment.
If your lordship, with that liberty, if your lordship...
So liberty I may not grant because that is not a subject matter now. Because visitation and contact right is a fresh cause of action and there is no res judicata also. Because me granting liberty will be as if I am interfering in the order appeal.
I have application to that effect. That has been
if you can, you will make an application to that effect.
I have already made an application.
Before the trial court or here?
Here, my lord. Before the trial court it was made, and on that application direction was made. Now presently also in the appeal, my lord, I have filed an application.
But as you have very fairly stated and you have examined the case brief orders, there is no order to that. Suppose there is a order rejecting your visitation and contact right, then this court can issue notice and ask them. Now yes. So that is what we were interacting. I was asking you.
Yes.
So I just whatever you have read, you have told me. Very correctly you have said that there is no,
there is no final order on that application. Then that application direction was made for production.
No, that is production is something different. Production before court is something different. But whether pursuant to your application for vegetation rights. So whether an order has been passed, I think that has not been dealt with.
No, that has not been dealt with. If your lordship permit me, then I will pass the order.
No, you read it.
The order dated 21/11/2017. Learned counsel for both the sides.
So first actually you find out whether there was any IA or MP, whatever being the nomenclature.
That
miscellaneous petition ke IA thila ki?
That reference I could not found, but there
is a coordinate. Because it was so difficult a case, so purposefully they avoided that kind of a situation where the child will be invited to say something and it will be recorded by the court. They simply allowed the court to take its own course, the decision. Because of conviction, whether now the father will be allowed or not? That
May
much.
place the two
Please, please place it.
21-11-17. Learned counsel for both the sides are present. Witness Vibhuti Bhushan Mahant of PW2 is present. Learned counsel for the opposite parties filed a petition praying for time for cross-examination of the said witnesses on the ground that the senior counsel who is conducting the case had been at to Champua. The opposite party number 1 is produced from jail custody. Present petition number 1. In consideration to the submission of the learned counsel for the respondent and on consent of other side, the case is adjourned to 30th-11-2017 for cross-examination of PW2 subject to payment of cost of rupees 300. The opposite party number 1 submitted that a petition is pending in this court wherein he has prayed that the petitioners be directed to produce the child, that is his son, who is residing with them. Perusal of the record reveals that in spite of direction issued...
That is a different petition, Mr. Panira. You have understood it correctly. I have understood correctly. Production of child before the court is something different. Vegetation and contract right is completely different.
Yes.
So I think we are on the same page. Production was to before the child for interaction with the court. Before the court with the father or whatever, that's a different thing. But it was production before the court, but not vegetation and contact right of father.
Right.
Correct.
Defect.
So
I have also instructed to get that copy of the petition. The petition they are referring in this order, the copy of the petition.
Petition the nahi.
Nahi itre.
आपनकर petition थिले मु सेटा MP की आई अच्छी की first question. आपण भी forensic examination करे पड़ो. When you are as a lawyer, you have to civil lawyer हेले भी आपण को forensically जीवक पड़ियो. Basics knowledge ठीक भूलवा ले जो. First principle आपण केमते apply करिवे. Pleading अच्छी की नहीं. Pleading रे कौन order हेची.
Yes.
Court रो finding अच्छी की नहीं. Finding अच्छी की नहीं को order कौन हेची. एटी तो देखिबे कौन. I think they have not pressed and I rightly so. ଯେତେବେଳେ ଆପଣ ଯିଏ କଷ୍ଟଡି ମାଗୁଛି ସେ ମର୍ଡର ଆକ୍ୟୁଜ୍ଡ ହେଇକି ଜେଲରୁ ଆସିକି ପ୍ରଡ୍ୟୁସ ହଉଛି ସେତେବେଳେ ତ କୋର୍ଟ ପାଇଁ ଇମ୍ପସିବଲ କାରଣ ସେ କଣ କଷ୍ଟଡି ଦେଲେ ଜେଲରେ ପିଲାଟା ନା କଣ ତ ସେ they were in a hurry rather the system should be no child should be there in the jail custody.
କଷ୍ଟଡି ଫାଇଲ କରିଥିଲେ ମ୍ୟାଟର୍ନାଲ ଗ୍ରାଣ୍ଡପେରେଣ୍ଟସ that was allowed. ସେମାନେ ଫାଇଲ କରିଥିଲେ ଫର
ଆଚ୍ଛା ସରି ହଁ ଆପଣ କହିଲେ ସେଟା yes ଆଜ୍ଞା ଆପଣ ସେଟାକୁ ସେଇଥିପାଇଁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି
challenge. If your lordship,
they are a difficult case. This is a very difficult case.
If your lordship call for the LCR, because
ଲାଣି ଲାଭ କଣ ହବ ଆପଣ ତ ସାର୍ଟିଫିକେଟ କପି ଆଣିଛନ୍ତି
ମୁଁ ଆଣିଛି
ଏଠି ଖାଲି କେସ୍ ପେଣ୍ଡିଂ ରଖିବାର ସାର ହବ ଆପଣ ଯେପର୍ଯ୍ୟନ୍ତ ଏଠି କେସ୍ ପେଣ୍ଡିଂ ରହିବ that also I may tell you that to assist you. ଆପଣ କେମିତି ସେଠି ମୁଭ୍ କରିବେ ଭେଜିଟେସନ ଆପ୍ଲିକେସନ?
No, I can't.
That's the problem. So that was the hint to you also.
Yes. And the last date.
ଆପଣ ଯଦି ସେଠି ଭେଜିଟେସନ ରିଜେକ୍ଟ ହେଇଯିବ ଆପଣ ଏଠିକି ଆସିବେ that's it. I mean ଆପଣ next day କୁହନ୍ତୁ come back with your you are very clear in your approach and further clarity you come back.
If your lordship passes the matter over, then I will talk to the client.
ठीक ଅଛି ନହେଲେ କାଲି ଛାଡି ଆପଣ next week ରେ
present there, Millard.
Okay.
I will talk to him and
pass over. Yes, next please. Call करନ୍ତୁ item. The matter is listed for orders, indicating in the cause list that defect pointed out by the stamp report has not been removed. Stop. Para. The matter was presented before this court on 12/9/2022. Stop. After 3 years, it was listed for removal of defects before the learned deputy registrar into bracket J, the judicial lecture, better judicial. Deputy registrar into bracket judicial, comma, logima for removal of defects. And 3 weeks time was granted. 3 weeks time was granted for removal of defect. Stop. Para. Thereafter, The matter was listed before this bench on 11/3/2026. None appeared for the petitioner on repeated calls, granting further opportunity to remove the defects as pointed by SR. 10 days time were granted. 10 days time was granted. Stop. Despite giving sufficient indulgence, the matter is not prosecuted by the petitioner. Stop. The matter shall be listed for orders in the week commencing. ହେଇପାରିବ 13/4/2026 indicating that the matter shall be disposed of. Stop. Copy of this order along with the next date of listing shall be communicated to the learned counsel for the petitioner by the registry. Yes.
18.
Ms. Pushpanjali Das on behalf of C. Vidyabhushan for the petitioner. The petitioner husband in the marriage is before this court, challenging the order passed by the learned judge, Family Court Bhadrak, dated 30/8/2022 in CR.P. number 349 of 2019. The said CRP was filed by the said interim application was filed in the CRP by the wife in the marriage and two minor children. One from the wedlock. The petitioner husband before the learned trial court had sought for DNA examination of the children born from the wedlock. And the learned judge family court disposing the petition of the petitioner husband observed thus. After going through the averments to Neki, page up to page page 10. After going through the averments, page 11 Soruchi for hearing. Today, the matter being in the list is mentioned by the learned counsel for the petitioner at the beginning of the day's proceeding. Stop. Memo of date is filed which indicates thus. Court Kotel. Stop. The memo shall be taken on record, scanned copy be updated. Stop. Para. In view of the memo filed, the petition stands disposed of. The copy of this order shall be forwarded to the learned judge family court Bhadrak to be tagged to be kept in the records of CR.P. number 349 of 2019. Yes, next. Pass over Mr. Panigrahi.
But he was hearing the entire discussion and is ready to file application, approved application for the.
So not pressed?
Yes.
So you file a memo?
Yes. Well, only with that observation, maybe there
So I will say that he shall prosecute his legal remedy.
Yes, in
as
view
it be available.
in view of the present interim
Because the problem is that suppose now since they have won the case, they have the custody, they will challenge this order again in Supreme Court.
Only
we must understand the consequence.
Only
Because
observation.
here this particular judgment has not rejected your application for contact and vegetation rights.
Yes.
That has not been rejected.
No, with regard to custody only.
Only custody. Custody is the last objective.
Yes.
I think they should have been more patient actually in getting custody. Of course, I'm sorry, again, they should have been more patient in filing appeal or waiting for the time.
Fine. So only filing of that interim application for visitation right, if your lordship refer it in the order, then
So interim application
it will be helpful.
No, it will be a normal application.
Yes.
Now the application for vegetation and contact right will be for only application afresh. It cannot be a CP. Because this will stare at you.
Yes.
I'll dictate after I come back. Rest of the matters after recess. There is a special bench. Mr. Rapha, your matter is? Senior Mr. Rapha?
28, first item of hearing. And probably I'll be filing a reply, a rejoinder to the counter filed by Mr. Klein.
So much time would not be left after recess because I think special bench is at Ketavada? At 3 p.m.
Take any date, man. I'll start to Mr. Klein.
So you can take a date.
Should I say a date?
Yes, yes. आपको केबे ही परियो 28 तारीख 28 टा केबे को ही परियो मिस्टर बारिक
11/5
11/5 है
11/5
और 4/5 है 4/5 है no, actually the pattern of hearing is that even orders matter are getting finally heard, so that is how to reach becomes difficult.
4/5
4/5 नहीं कैलेंडर टा नहीं माने आपनकर नेक्स्ट वीक ऑफ द लास्ट वीक
अच्छा हो सर
week commencing 4/5. Any other matter where the parties are present and they want a date, just suggest.
Item 25, there is a difficulty, my lord. Notice was issued on the question of admission. But the
25, I'll be taking up. I'll try to cover the orders.
Okay.
Rest of the matters I'll call, but the senior should not wait.
Okay.
Because when
Item 22.
But up to 3.
Item 22, my lord, the state was directed to file an affidavit.
ଆପଣ ମିଷ୍ଟର ପ୍ରଧାନ
My lord. As a notice.
ଆପଣ କହୁଛନ୍ତି ଯେ ଯୋଉ refuse to send ତାହେଲେ sufficient ହବ ତ ଠିକ ଅଛି ଦେଖିବା
I'll do it.
Item 22, my lord, the state was directed to file an affidavit. My lord, may
This 22, my lord.
22 has to be go for admission. Suppose we include everything in orders, then it becomes difficult to manage the list.
Fine.
Some matters should be hard for admission. Hearing को पछे न जाओ किंतु after notice आपनकर जदि hearing हबो orders रे, then orders matter like just now for sufficiency of notice. Item 25 आपनकर 22 it has to be hard.
This 22, my lord, dependents, lordship was directed to be listed on for orders because, my lords, after my lord's direction, there was an inquiry which a report was found out, which is favoring the.
Achha, that matter.
So we
Okay,
are supposed to file an affidavit. My lords, we have communicated. It is already prepared also, my lords.
केबे चाहुछन 22 टा?
It is that's within a week we'll file it. So that it can be disposed.
Within week ले dispose of it. Week commencing 13 ना 20 22 टा को for order से रहइबो. Week commencing 24/26. Yes. Yes.
File has been sent to mediation.
Sir, take a date, sir. Actually, once the paucity of time intervenes, I should not pass orders. So uniformly, you take a date. Kebe chahuchandi କହିଦେବେ. I'm here to dictate Mr. Pani because certain things are happening on a beyond our mind control and unforeseen. Not exactly judicial work. Some other
2 weeks after.
date करूँ सर का मैटर टा we commenting 4-5 क्वेश्चन 32 ठीक मत अरे आपन को नाम 32 रे आपन हां आपन ना अछि अदर साइड को इन्फॉर्म कर देबे जदी पॉसिबल आपन का मैटर सर
With due apology, I have some urgent matters. I have received the D number, but I want to list for today.
No deviation, no favorite lawyers or the favorite court.
Tomorrow is the last.
I will not to do that. Not to do that. I'm happy also.
Tomorrow is the last.
Whatever.
Public.
केस रो भाग्य गोटे थाए बहुत पुराना कथा मु प्रथम बुझी पार नथिली जातक भी थाए तो से भलिया कथा प्रीमैच्योर सिक एबे छुआ प्रीमैच्योर थिले के आरंभ निकुर रहे न्यूनेटल इंटेंसिव केयर यूनिट आपनकर निकुर अछि बर्तन केतेबेले बड़ होबो ये हो डिफरेंट थेरापी दिया है कि पानी के साथ सेमतिया अछि बट ही स्मार्ट ताकू से निकुर बाहर करी ये करी ताकू से बर्तमान सजिसे पे चाइल्ड ते बर्तन जॉब पढ़ाती सजीवती से बुझी जाइछन ठीक ओके सब्जेक्ट मैटर कोन
पैडी प्रोक्योरमेंट
टू सर मोर सब्जेक्ट मैटर आपण एई जिंसडा देखिले आपण भूल आउटडोर भी देखिले देह तो एक खराब आउट पार्टी प्रोक्योरमेंट बिल्कुल सब्जेक्ट मैटर नो मिस्टर लेंका जी किंतु कॉन्सेंटेड नाहंती सो समहाउ मोर जो डिस्ट्रीब्यूशन पीडीएस पैडी चावल बंटन धान किणा अलग बेंच अछि मोस्ट लाइक जस्टिस कहि दोची भी आपण को जस्ट मेंशन करथिले मिस्टर नायक जस्टिस आइटम 12 रे अछि इनएक्शन ऑफ रेवेन्यू अथॉरिटीज सॉरी कोर्ट नंबर 12 आई एम सॉरी कोर्ट नंबर 12 ଆଉ ଆପଣଙ୍କର ରେଗୁଲେଟେଡ୍ ମାର୍କେଟ କମିଟି ଯୋଉଟା ପ୍ରୋକ୍ୟୁରମେଣ୍ଟ ଯୋଉଟା ସେଟା ଡାଇରେକ୍ଟ ସବଜେକ୍ଟ ମ୍ୟାଟର ଅଛି କୋର୍ଟ ନମ୍ବର 21 ମୋର ହଉଛି କଣ୍ଟ୍ରୋଲ ଅର୍ଡର
এটা ইলেকশন অফ দি অথরিটি
হোয়াট ଆପଣ ଦେଖିବେ ସେଟା ଆମେ ଜଷ୍ଟ ଏବେ ଜଣେ ଗୁଡେ ସମୟ ନେଇ ତ ଖୋଜାଖୋଜି କରି ବାହାର କଲୁ ମିଷ୍ଟର ଲେଙ୍କା ନାହାନ୍ତି ସେ କିଣାଟା ହଉଛି ଅଲଗା ଏଟା ଆମର ପ୍ୟାଡି ଆମର ଚାଉଳ ଆମର ଏସେନ୍ସିଆଲ କମୋଡିଟି ଆକ୍ଟ ରେ जो पीडीएस कंट्रोल ऑर्डर
my lord. It shows execution is pending before the vote of 6th April lordships. That is my difficulties, my lord. There is no stay was there. Unless execution stay up, execution exhausted or they will suffer, my lord.
अदर से नाहंती तक absent से इंटरिम ऑर्डर करियो तंग कोंतु तंग आनंतु सेटा जदी काने एटा भी रीच करिवनी मैटर रीच करिवनी बट टुडे द ओनली हाफ एन आवर लेफ्ट फ्रॉम टुडेस टाइम ओनली सेविंग ग्रेस होची आई कैन स्पिल ओवर because I am saying this continues after also.
That was fixed on 6th April. That was my difficulties, lords.
नहीं order थी like interim order किसी ही नहीं. ताको आनंतु देखंतु. मिस्टर दास तो दिल्ली पड़े थी आपण मिसेस भगत को देखंतु.
I will wait up till my lord.
No, his submission has been noted also. Right, counsel for the opposite party submitted. Opposite party is facing difficulty without the maintenance as directed being paid. So these are the cases Supreme Court has directed to be disposed of. So इतने आपण किसी करिए नहीं आपण प्लान जा करिए ना you get a brief as good as it is. So इतने कौन अच्छी हाँ से सिक्योर करिवेनी कि पैसा देबेनी से तांको निष्पत्ति ना सेतरे आमे कोन तांको इबली असिस्ट करिवु नॉट टू कंप्लाई विथ द लॉ एंड डिक्री
And for husband.
Correct, sir. आपण देवाकू चाहुनाहांती. That is your difficulty.
Whatever interim matter I have paid.
So execution the best defense है ना satisfaction of the decree. आपण executing court रे देखेबे. तापर executing court जदि ताको स्कले सेटा को अपन कोई कोर्ट चैलेंज कर सकते.
This is right and before this are six. So it was all other than suffering.
No, से ताकर मुरे bottom में order sheet देखिए actually. Paperless advantage सेटा. Any brief can be seen. What is the order? See, upon you mentioned, second February, he has mentioned that the opposite party is facing difficulty without the maintenance as directed being paid. There. So, Padina, you take your seat. I'll dictate the order, sir. I'll take some.
Account 16, I'm filing the memo.
एते कौन लिखिले तो अपन मेरिट रे कौन अपन तो डी लाइन लिखिबे कोन फॉर द टाइमिंग यू डू नॉट वांट टू फेस द अपील
Challenging पोस्ट लिख 3J.
The appeal has been filed challenging the order passed by the Learned Judge Family Court Kendujhar dated 6/9/2018 in MISC miscellaneous civil application into bracket GUA number 38 of 2013. By the said order, the application filed by the maternal grandparents of the petitioners.
Minor child.
No, petitioner, no. The maternal grandparents of the minor child who is son of the opposite party, number one, before the Learned Judge Family Court. Sentence ta kaun likhila utar padli.
Application filed by the maternal grandparents of the minor child who is son of open party for the Learned Judge Family Court.
Seeking custody of the minor child born on 23/12/2012 माइनर को पार्टी करना थिले नहीं कस्टडी वाज करने सेंटेंस कंप्लीट है कस्टडी होता हाँ the mother of the minor child died on natural death 04 unfortunately died unnaturally on 04.08.2013. All four have been convicted. Yes. The respondents before the Learned Judge Family Court, 1, 2, and 3, that is the father of the minor child, father's father and mother, that is paternal grandparents of the minor child, were convicted by the Learned Sessions Judge Kendujhar in ST case number 67 of 2014 arising out of GR case number 1013 of 2013 of STJM Kendujar for committing offences under section 304B, 498A, 304B.
My lord. And 34.
34, read with 34.
And DP Act also, 4 DP Acts.
And 4 DP Act, 498A, 304B, read with 34, and section 4 of the Dowry Prohibition Act. The Judge Family Court considered the provisions contained in the Guardianship Wards Act, Section 8, the Hindu Minority and Guardianship Act 1956. You look at Hindu Minority and Guardianship Act 1956, Section 6 of Hindu Minority and Guardianship Act. 6, that's why, comma 13. 6 and 13. The Lord Trial Court, Lord Judge Family Court also considered the welfare of the child and observed thus at paragraph 9 of the judgment. 9 of the order. Paragraph 9, page 17, Rachi. Internal page 9, 7. All the three respondents were convicted, upon being convicted, were awarded sentence of life imprisonment. Stop. During pendency of the application, the respondent number 1 father was in custody. His parents, that is the grandparents of the minor, were on bail. The Lord Trial Court has considered that the maternal grandparents of the minor is a grandfather. Grandfather of the minor is a lecturer in Jasipur College. His wife, that is the maternal grandmother, is a homemaker. To grandfather likely, is it about 51 years? Grandmother, maternal grandmother, is it about 45 years? So, the Judge Family Court has considered in detail the income of the maternal grandfather parents compared to the father as well as the maternal, as well as the paternal father, as well as the paternal grandparents. Stop. The custody was granted to the maternal grandparents. This court does not find any error apparent on the error apparent in the order. It has been the conclusions have been arrived at after analyzing the evidence on record as well as considering the provisions of law. Also, the law laid down by the Honorable Supreme Court regarding welfare of the child. Stop. Para. At this stage, the learned counsel for the appellant files memo of date which indicates the following. Para. The appeal is disposed of as withdrawn. Para. The petitioner shall have liberty to seek remedy under the provisions of law as would be available to him for vegetation and contact rights with the child. Stop. The learned counsel for the appellant was heard at some length. Earlier, the matter was heard on 9/3/2026. So the first sentence. Yes.
Correct.
19.
The matter is listed for orders, indicating in the cause list that the defect pointed out by a stamp report has not yet been removed. Stop. The matter was presented more than 3 years back on 26/9/2022. It was listed before the learned deputy registrar into bracket judicial, comma, logima for removal of defects on 21.11.2025. Stop. The learned deputy registrar granted 3 weeks time for removal of defects. The matter was again listed on 11/3/2026 when no one appeared. Stop. However, granting further time for removal of defects, the matter was adjourned. Granting time जो लिख ले, granting 10 days time for granting 10 days time. Then para. None appears for the petitioner when the matter is called. Apparently, sufficient indulgence has been shown to the petitioner to prosecute the matter. Stop. The petitioner remains non-responsive. Stop. The matter shall be listed for orders in the week commencing 13/4/2026, indicating that the matter shall be disposed of. Copy of this order, along with the next date of listing, shall be forwarded to the learned counsel appearing for the petitioner by the registry. Yes, next.
Item 20.
My lord, I am appear for the petitioner. Kindly to be taken up next week.
ଆପଣ डिफेक्ट रिमूवल आज्ञा 31/10/25 डिफेक्ट रिमूवल ପାଇଁ ରହିଛି ଆଜ୍ଞା। এটা ତ ମୋର କାଇଣ୍ଡନେସ୍ କି ଆପଣଙ୍କର ଏକ୍ସୁବେରେନ୍ସ ରେ ହବନି। I may be very kind, you may be very exuberant, but ସେଥିରେ ଏଇଟା ଲିଗାଲି କରିବାକୁ ପଡିବ। କେମିତି ହବ ଏଟା ଆଜ୍ଞା?
Next week.
ନେକ୍ସଟ ୱିକ୍ ଟା କେମିତି କରିବା ଆଜ୍ଞା? 31/10/25 ରୁ ମୁଁ କେମିତି ନେକ୍ସଟ ୱିକ୍ କରି 31/10/25 ରେ 3 week दियाला वर्तमान ହେଇଗଲାଣି ଆଜ୍ଞା ଆହୁରି 6 ମାସ ହେଇଗଲା जोटा 3 सप्ताह थिला 6 मास पर मु तो नेक्स्ट वीक कोन करिवि आपण जदि करिबेनी केस करंतुनी बट लेट अस नॉट आपण को नाटा बेटा
सबिता बेहरा
सॉरी कुन संगीता बेहरा सबिता बेहरा को पावर नहीं on behalf of Mr. Naik Miss MS Sabita Behra on behalf of SK Naik for the petitioner. The matter was presented before this court on 21/12/2022. After almost 3 years, it was listed on 31/10/2025 for removal of defects before the Deputy Registrar, Judicial, Law Jima. Stop. The Deputy Registrar granted 3 weeks time for removal of defects. Stop. Thereafter, the matter was again listed on 4/2/2026 before this bench. And none appeared, despite the matter being repeatedly called and passed over. Stop. To grant further opportunity, the matter was directed to be listed today. They directed to be listed on 23/2. Stop. On 23/2, no one appeared for the petitioner. Stop. Today, the Lord Counsel for the petitioner again seeks adjournment. Stop. She is apprised of the fact that the matter is kept pending without any steps being taken for the last more than 3 years. Stop. 6 months have elapsed since time was granted to remove the defects within 3 weeks. Stop. The matter is adjourned reluctantly. To be listed in the week commencing 24/4/2026. It shall be indicated in the cause list that the matter will be disposed of. Yes. भूलिएगा Inadvertent typographical error has crept into the order number 1. आगे लिखिए order number no order dated 5/3/2026. The order numbers shall be corrected as 4 by handwriting instead of order number 01. Court arrival court 01 arrival court. The correction shall be reflected in the order sheet. Stop. तापर एटा लिखिबे. Yes, next.
Item 21.
Mr. Suryakant Dibedi for the petitioner.
On behalf of Mr. Suryakant Dibedi, my lord.
You are Mr. Hota. Sorry, I forgot you.
Das, my lord.
Mr. S.S. Das. But you have power here?
My lord.
S. Das.
My lord. Today his father's death anniversary, my lord. Shraddha se nahati, my lord.
Mr. Pursuant to the order dated 18/3/2026, registry has intimated the order to the Lord Counsel for the petitioner, Mr. Dwivedi. Mr. S. Das, Lord Counsel. अपन ऊपर S. Das appearance देखिए. Mr. S. Das, Lord Counsel, who has also power, appears and submits that due to personal difficulty of the Lord Counsel, the matter may be adjourned.
Ma'am.
Accordingly, the matter shall be listed for orders.
With commencing 24.
With commencing 24/4/2026. Yes, next.
Item 23.
23, my lord, I pray 1 week time.
It may please your lordship, I'm on behalf of Mr. Mishra.
Yes, please. Your name, sir, Mr. Pradhan.
My lord.
Mr. T. Pradhan for the petitioner. Prathama TRPC 323.
Yes. My lord, last occasion opposite party submit କରିଥିଲେ ଯେ petitioner ଯେ expire କରିଯାଇଛି କିନ୍ତୁ ତାର details ଟା ପାଇନି memo ଟା file କରି ହଉନି ଯେହେତୁ
Madam, just kindly tell your name again. I forgot your name.
Itisri Mishra.
Miss Itisri Mishra on behalf of Arijit Mishra for the opposite party. Please. The learned counsel for the opposite party, a petitioner, seeks further time. 6 refers to the learned counsel for the petitioner refers to the order dated 18/3/2026 and seeks further time to enable him to obtain instruction. As the matter shall be listed in the week commencing 24. Is it instruction as well? That is called orders as well. For orders on 24.
Yes.
In the week commencing 24.
24.
Then is detached, na?
24, my lord, I am for the opposite.
Just give me a moment. TRP CRL 71 of 2024. Mr. Miss Mishra for on behalf of Arijit Mishra for the petitioner. So Ansuman Sethi, additional standing counsel for the OP number 1. Mr. T. Pradhan. So T. Pradhan for the OP2. The matter is listed with the connected TRPC 323 of 2024. Stuff. In view of the order passed in TRPC number 323 of 2024, the matter shall be listed along with the said petition on in the week commencing 24. The week commencing 24.
Item 24.
24, your name?
M.R. Das.
Mr. M.R. Das for the petitioner, Mr. Ananga Kumar Otta for the opposite party. Learned counsel for the opposite party being present at the virtual court, High Court of Orissa at Jajpur addresses arguments. Yes, Mr. Otta?
My lord, may I pray? This is a matter between the father and the daughter, my lord. I pray for mediation, my lord. The matter can be disposed.
Mediation, will you pay the money? Court has difficulty in paying the money.
I am paying, my lord.
In case of negotiating a money decree, court has limitation.
No, my lord, money, so far as maintenance is concerned, I am paying.
Correct. So there is no scope of maintenance mediation. If it is a money suit, then it's a different thing. Whether you can always. So what the mediator will do?
Lord, the petitioner has prayed for my lord, enhancement of the maintenance.
Oh, that is on the merit. You are saying, let us not keep on shifting the issue. You are saying that mediation. So what mediation can happen when there is a direction for maintenance? That's the first question. The jurisprudence has not developed because I can't direct the state to pay. I'm just giving you an example.
My lord.
What kind of mediation? If the father and daughter they agree, so let them agree for about a Kuntu. First of all, both the learned counsel should make up their mind. I mean, your learned colleague, I am asking him.
My lord, I have the instruction that they have talked. Both of them are talked. And
any settlement in this kind of matters it's always a welcome step.
My lord.
But the limitation is that in the pretext of mediation, it is kept pending. Not in this case. You'll be surprised in Lokadalat, somebody appeared from Barampur, a lady. She says that for the last 13 years, she and her daughter are in abject penury. And it is kept pending in the Lokadalat. And I mean, since it is Lok Adalat, it is not available, but it is live. Everyone has seen that. I still remember the name of the lady also. So that happened. So these kinds of, I mean, these kind of things, what can be done?
As yours, it is.
Yes, yes.
It is posted for hearing the petition for condonation of delay.
I mean, let it come under some other day, on some other day. ଦେଖନ୍ତୁ mediation ପାଇଁ ପଚାରନ୍ତୁ ହେଲା as paid for by the learned counsel for the parties, the list in the week commencing, list for orders in the week commencing 24 mediation पे କାজ କରିବେ ନା 4-5 କରିଦିଅନ୍ତୁ ଆପଣ ସେଇଟା ପାଉଛନ୍ତି ଯେତିକି ପାଇବା କଥା
last 2 months they are not paid.
How can the court interfere when the father doesn't pay the daughter?
The father is paying. He is paying.
Okay. Se କହିଲେ ଯେ ଆପଣ I hope you have heard him, your learned colleague. ସେ ଅଛନ୍ତି ଆପଣ ସେ ବୁଝିଗଲେ ହଁ ସେ କହୁଛନ୍ତି ପାଇନାହାନ୍ତି ବୋଲି ଆପଣ ବୁଝନ୍ତୁ ନିଶ୍ଚୟ ପଚାରନ୍ତୁ. Hopefully they will agree. Yes. Next item 25. But 4-5 कर दियो.
25 might not. Well, here I have challenged the quantum of maintenance awarded against me. On that basis, when a notice was issued on the question of admission, but there is a postal noting that it has been refused to be accepted. For which it is.
Are you paying?
That is no.
Not maintainable. Dismissed. Has to be dismissed.
Well, with the final judgment.
So whether the other side agrees or accepts notice is immaterial because this is a classic case. This I have been discussing.
Yes.
That the husband has become Supreme Court and stayed the matter. So let him stay.
The matter has not been stayed. Matter is not stayed.
No. He behaves as if he has stayed the matter.
The problem is that
family judge order a decree is not a decree.
No, it is a decree. I bow down to that, man.
So the jurisprudence has evolved a lot.
I understand.
Lot of guidelines and direction.
But they are refusing to accept notice. That is, they should appear and.
So there will be hard experience.
The problem is that order has been passed from the initiation of the proceeding. The award has been passed. My only ground is that from the date of judgment, it is passed. I am ready to willing to pay.
Sir, which is the last decision you read on this?
I bowed down, but
please don't bow down, sir. There is no point in bowing down for a lost cause.
It's not a lost cause. If my lord may interfere into the matter, my lord may find out that all my
complete lack of preparation.
No, my lord.
Complete lack of preparation in this branch.
No, my lord.
Yes, what is the case law on this?
That is true.
My lord, is not the case law.
I will satisfy that point of my lord, but let them appear at least.
Mr. Pradhan, you see, I didn't have much exposure in this branch.
I know.
But still I practice. I as a judge at Harvard.
I will satisfy my lord. I will satisfy every question, my lord.
Nothing is there.
Let them appear, my lord. But the deliberate.
Where non-appearance doesn't, the challenge cannot succeed.
I know.
There is not a single case
I
on
pay
this.
some amount as per my
That you are arguing a lost cause.
No.
Wrong, complete wrong submission of law.
I have a ground, man. I have a
so be that. I'm asking you.
My asset liability, which was submitted before the court below, has completely been ignored, man.
You see, the assets, suppose they would have granted you 8 lakhs. You must understand that when the court grants you 12,000, assets and liability, unless somebody, the 12,000 is for the daily laborer. So if you are more than a daily laborer.
No, well, I have stated in my asset liability that I am unemployed, man.
Fair enough. You are a daily laborer. So the jurisprudence has developed as a daily laborer.
I will deposit some amount, man. Please understand my difficulty, man.
No.
I don't have a source of income.
Mr. Pradhan, I'll record that. Your difficulty not to maintain the wife and child.
I will. No, I'm not saying that, man.
No, you have said and now I can't rewind it.
Difficulty is the amount.
It's not eraser that I'll put eraser and write it down.
Difficulty is the amount, man.
No. Decrees are not to be bargained, and that too after. Do you know why I'm saying that you have not? Some semblance of reading should be there on this point. Which is the law on this? What is the law on this?
That is why I have not filed an IA for stay of the order, sir.
Whatever, sir. What is the law on this?
As to what, man? I'm sorry, man.
Your point you are arguing. That from the
quantum of maintenance.
quantum, second part is that from the date of judgment or date of the order or the
That
date
I have to go through, my lord. I'm sorry, I'm not. That I have to go through, my lord. But the quantum has to be decided.
I have to record that.
But some fair
I'll
length has
counsel
to
for
be
the
given.
petitioner. Mr. Abhinandan Pradhan for the petitioner. I'll take some time in dictating.
Well,
You please, you can take your seat.
Yes.
Any doubts, I will ask you.
well.
Pursuant to the notices issued by this court by order dated by the coordinate bench by order dated 17/6/2025. Office note put up by the registry indicates that after the requisites were filed by as noted by order dated 21/7/2025. The notices were issued. The notice has been returned unserved as per the office note dated 19/2029. Has been returned unserved as per the office note with a postal remarks that addressee refused return to sender. And regarding OP number 1 and OP number 2, addressee left without instruction. Return to sender. In view of the provision contained in CPC लिखिए and General Process Act लिखिए, the notice to OP number 1 shall be treated to be sufficient. Now the issue arises whether due to refusal of due to sufficiency of notice on the opposite party, this court will proceed further in the matter. In considered opinion of this court can proceed in considering the merits of the case in absence of the opposite party. Para. The petitioner husband in the marriage is before this court challenging the judgment dated 21/2/2025 passed by the Lawrence Judge Family Court. This will be the last matter before the special bench. Because 3 p.m. is the special bench. This has to be the last matter. In criminal proceeding number 275 of 2021. The same proceeding was at the instance of the wife in the marriage and minor son aged about 9 years, born from the wedlock, seeking maintenance under the section 125 of CRPC, into bracket, seems repealed and substituted by pari-materia provision contained in section 144 of the BNSS 2023. Bracket closed. Chokos was filed on behalf of the petitioner or by the petitioner herein, who was the opposite party before the learned trial court. Affidavit of asset and liabilities were filed by the petitioner, wife, was filed by the opposite party, husband, before the learned trial court. Before the learned trial court, the petitioner wife examined herself as PW1 with another witness as PW2. The respondent, the opposite party husband, examined himself as OPW1 and another person as OPW2. No documents were marked as exhibits on behalf of the petitioner, nor any documents were marked as exhibit on behalf of the opposite party. The learned judge, family court, analyzed the evidence in detail. As would be evident from the judgment at paragraphs 11 and 12. 11, 12, 13, 11, 12 and 13. The said paragraphs are reproduced herein. Regarding the affidavit filed by the opposite party husband, the learned court has not gone into the details. However, considering the plight of the lady as well as the study of the and requirement of education of the minor child, has awarded maintenance rupees 8,000 and rupees 4,000. So, in order to challenge the order passed by the judgment passed by the learned trial court, it is contended by the learned counsel for the petitioner that the petitioner pleaded before the learned trial court that he doesn't have any income. Two, the order of maintenance should be granted from the date of application, should be granted from the date of order, not from the date of application, as has been done by the learned judge family court. Yes, anything else, Mr.?
No.
These 2 points.
No, my basic point is quantum.
The quantum of it is submitted that the quantum awarded by the learned judge family court is not commensurate with the income of the opposite party. The scope of 125 CRPC and its application to cases has been authoritatively decided by the Honorable Apex Court in Rajneesh versus Sneha, so and so, so and so. The paragraph regarding date of payment of monthly maintenance, that is whether from the date of application or from the date of order. It has been again it has been answered authoritatively by the Supreme Court following the decisions of this court, Supreme Court in Reliance versus Neha, following decisions of this court, Supreme Court has followed Odisha High Court. That is the reason I was telling you that you should have reflected on this. Relying on sentence টা? Quoting with approval, judgments of this High Court. The relevant paragraphs are reproduced here. The scope of interference of this court in an order by exercising revisional jurisdiction, more particularly seeking revision of orders passed in applications under section 125 CRPC has been dealt with by the Honorable Apex Court in Samima Faruqi. The relevant paragraphs are reproduced here. The Lord Counsel for the petitioner has adjournment to address on the above issues. Rest of the actually something is being left for you to ponder over. Because if I conclude it today, actually it is concluded. Nothing more, no more is left. Because whenever you must examine by applying your judicial mind and reading. Upon evidence किसी नहीं actually. अपन water resource department चाकरी करचन.
तार भी किसी document नहीं. That's only a
correct. देखिए सेटा को अपना cross examine करके सेटा किसी करी पाना.
That I'm nothing.
All these things the Supreme Court says that if I interfere, then that non-application of mine.
But that was without any.
And 12,000 टंका आपण जदी 20,000 टंका भी देछन आपण कहि थांते आपनकर minimalist approach हेगला कोर्ट रो और जदी आपनकर गोटे exorbitant amount देबे कि गोटे little bit higher केबे चाहउछन
any time
एनी तो नाही एकरो आ कंप्यूटर नोनी सेटा एनी टाइम बहुत थोर फीड करलेनी माय लॉर्ड प्लीज से भी होनी.
First week of May.
List in the week commencing 4-5-20-24. List for orders in the week commencing 4-5-20-24.
But with regard to the...
There is a bigger aspect to this, Mr. Pradhan. I must tell you that because we are doing it last week only. We prevailed. We were asking the Learned Family Court that how these matters are kept pending. Supreme Court has taken up this matter in state case management system. Maintenance matters, if you read that judgment, they have analyzed everything. 7 years, 8 years, 10 years are kept pending. That cannot be a method of law. Yes. So, what are the date नहीं जानतो?
That is why I am playing.
आपन को संग रे
Attempt the table.
कितने नंबर कहले?
Item 29.
Better page wise जानतो. There will be some. Let us make it little bit systematic. ଆମ ରୁହନ୍ତୁ ଆଜ୍ଞା 24 ରେ ଆପଣଙ୍କର ମିଷ୍ଟର ପ୍ରଧାନ ହଁ 26 ରୁ 32 29 ଡେଟ୍ କରନ୍ତୁ.
Will council 4
30 ରୁ 32 33 ରୁ 38
33 my lord.
33 yes please.
Madras matter my lord, I am challenging quantum. I want to take back my wife and
এটা ନାହିଁ provision ରେ ନାହିଁ
my lord.
125 ନା 24 ନା କୋଉଥିରେ ଏଟା ଆପଣଙ୍କର ନା domestic violence
105 ରେ 105 ରେ maintenance file କରିଥିଲେ wife.
105 ମାନେ domestic violence.
Oh what sorry 125.
125 ରେ provision ନାହିଁ. Wherever the husband wants to take the wife, he shall not be awarded any maintenance. ଆପଣଙ୍କର 125 3-4 always condition ଅଛି.
In respect of my request to the court below.
There is a problem. You have to be careful. Say question na jodi pacharichhe se konje I do not feel safe for that place. No court will allow that. That's a tricky situation.
My lord, there is a chance for you.
Seita apan तो सेटा सेतरे 125 रे कोन हे परियो 125 रे जदी हस्बैंड नमको चाहथिबो आवाज दबनी सेटा सेमति नाही प्रोविजन किछि नाही मु कोन कर परियो केबे केबे आसियो कोन मिस्टर राउतरे थिले ना कोन परा पळेले ठीक अछि डेट कर दियो 11/5 वीक रे
Item 37 lordships.
again so Sahoo
Yes, I think let it come my lord 6th April.
6th रे रखंतुनी काय गुडे मैटर पर
Yes, अच्छी तळगोटे
he has crossed already 300 in April.
Execution is pending. That is my difficulty.
Execution pending रखा जिबा एवं execution हबो बोली कहा जाय छै से जो कोड तार कोड चिन्नमा कोन सेटा गोटे प्लस राहुल सा लार्जर बेंच दीटा डिसीजन
Your Lordship, item 26 may pray for recommencing this. Yes.
इथर कोन आपण अछि 37
26.
आपण को 37
my lord.
वी कमेंसिंग करू 13 की 20 रखंतु 24 रखो yes
26.
Lordship my lord. The stage is required lordship unless I will have.
देखंतु सेमती कोन ताको सब मैटर में एमिति आगे हियरिंग हो
I find for execution.
ये आगे डिफिकल्ट द होल बिकॉज़ माने ऑनरशिप हियरिंग करिया पड़ियो
Your Lordship, item 26.
just one second let us complete it
Yes.
then item 38 to 40 yes Mr. Deal Mr. Pusti
Your Lordship, I'm praying for recommencing 24, Your Lordship. 20th April.
नहीं पर देखो तो already he has posted more than 300 plus matters
Yes, Your Lordship.
मतलब specifically adjourned दादर से मेरा add out
If it is at all possible, Your Lordship.
करम जल्दी मिस्टर ये जल्दी करम तो 27 से विक्रम
Yes, Your Lordship. I'm much obliged.
27.
Item 36.
Item 27.
27 yes
Week commencing 24 my lord.
कोडिया रखंतु कोडिया सब से कहले केमती मु मिस्टर धीर को मना करली एबे
29.
से 4-5 रे करंतु
4-5.
Unless in 27.
Item 36.
Unless in 27, I'm appearing for the opposite party.
Mr. Gaurav Das
My lord.
yes no I am not passing any order date to का automatic माने कंप्यूटर रे पोस्टिंग करा होची
My lord.
yes
My lord,
it saves time
item 36.
36 like that yes
36 day on the last occasion, my lord and senior was absent at the time of call. Fix a date for a year.
that is the date करंतु
We council 11/5.
11/5
Sir, aji कर दो.
आगे
Aji मु तो ready छी.
सर आज रेडी हेले मु ता पूर्व मेट्रो नौ पड़ियो मते ना आज एक्चुअली 3टा वाला अन्य बेंच अछि
So मैं
आपण रेडीनेस 3टा वाला सर जाई
मैं फास्ट वीक
तो रही छी मैं रही छी 11/5 को 11/5 वीक रे
Special.
हां yes Mr. Vishal was mentioning the
ना 30 थिला था डेट तो हेतु
30 से डेट जदी टाइम में कर देबे नले आसी दियो से कहू छ 11/5 पर वीक रे
11/5 पर वीक
Pardon to make a mention, my lord. Item 31.
31
Again, it is ready for final hearing. It may be posted to any convenient date, which my lord.
say time nahi chanti somebody else has appeared Mr. Bhuya
Yes,
I'm
my
just
lord.
forgetting his name say 4-5 Mr. I think Mr. Mr. mentioned
Okay. The only the interim.
I'm sorry Mr. Das Mr. Manmohan Das mentioned and he said 4-5
Okay. Then my lord, only the interim order may be continued because the
no,
is at the final hearing, my lord.
so 31 is specific adjournment date or what is the order
Till the adjournment date, my lord. If I remember correctly.
टिके आरो लिस्ट भी खोलिबे नहीं दीटा खुल्लो ना तो पैरेलली खुल्लो
दीटा साथ में जेहेतु सीपीटा फाइनल हियरिंग रे अच्छे माय लॉर्ड सेति पे इंट्रीम ऑर्डर खाली कंटिन्यू हे गले से प्रोसीड करिबेनी फाइनल आर्गुमेंट पे दैट इज माय ओनली एंडेवर माय लॉर्ड
टिल दैट देखो एट ए टाइम गोटी फाइल खुलिबो दीटा खुली परिबो ना पूरा पळेला असुविधा होछ ना Lekhotu Mr. S.S. Bhuya for the petitioner, 31. Mr. Manmay Das. Upon election, the inata, I think. Likhit later na Mr. Manmay Das for the Manmay Das likhiwe, it's the appear kariyo. Opposite party blank likhiwe. The matter is mentioned at the beginning of the day's proceeding by Mr. Das, Learned, Mr. Manmay, Mr. M.K. Das, Learned Counsel. Stop. He submitted that he has instruction to appear as the opposite party has obtained change. And he has been engaged after obtaining consent of the Learned Counsel who was appearing earlier. Stop. Upon filing of the Wakalatnama, name of Mr. Das, Learned Counsel shall be indicated in the cause list as well as the case brief. Stop. The matter is again mentioned by the Learned Counsel for the petitioner at the end of the day's proceeding as it could not reach. He seeks extension of the interim order. Para. Accordingly, it is directed. No, in the interim, it is directed. The order dated 19/12/2025, paragraphs 10 and 11, passed by the coordinate bench is reiterated and shall continue till the next date of hearing.
Much obliged.
Date कर दूँ ना Mr. Bhuya? Can you hear? अपन लोगों ने date कर दूँ ना
Yes, my lord. Any date convenient to my lord's board.
And submitted कौन लिखे? Interim order लेगी? Extend. ताप order चले काटी दियो. In the interim, it is directed that the CP number 541 of 2021 shall be adjourned beyond a date. Shall be adjourned beyond 11/5/2026 as would be convenient to the learned judge, the learned court in season of the matter, upon a prayer being made for the said purpose. Yes, next.
Much obliged.
Special list, item 1.
Say list kuja.
May it please, my lords. Lordship can may kindly condone my appearance on VC, my lords. I was there in the first hour. Am I audible, my lords?
Yes. Yes.
Instructed by the current Advocate General that you will conduct this case if your lordship keep it in 7th after 2 p.m.
Can I record that? Should I record or simply adjourn?
7th April.
ମୁଁ ଏଟା ରେକର୍ଡ କରିବି କି ଯେ ନା କଣ ସିମ୍ପଲି ରଖିଦେବି 7 ଠିକ ଅଛି ଠିକ 7 କୁ ରଖି ଦଉଛି ରେକର୍ଡ କରିବା
2 p.m.
ଠିକ ଅଛି
7 ରୁ ଅଛି ଗୋଟେ
7 2 p.m. ଅଛି
8 କୁ ରଖି ଦିଅନ୍ତୁ 2 p.m.
ଗୋଟେ ମ୍ୟାଟ୍ରିମୋନିଆଲ ମ୍ୟାଟରରେ ଯୋଉ 2 p.m. ସେଟାକ ଇନ ପର୍ସନ ସେଟାକୁ ଆର୍ଜନ କରି ହବନି.
Can I request your lordship to call it on 8th 2 p.m. then?
It is not the Mahanasi matter is madam.
The 9th 2 p.m. 9th to 2 p.m.
2 p.m. no better hବ ଯଦି ଆମେ effectively
ମୁଁ ଟିକେ handicapped ଅଛି ତ that's why I am requesting. ଆଉ କିଛି ଅସୁବିଧା ନାହିଁ.
7th ରେ ଆପଣ କହୁଛନ୍ତି
7th ରେ ଟିକେ difficulty ହେଇପାରେ କଣ କହୁଛନ୍ତି ଆପଣଙ୍କ
Mr. Lenka kindly talk to the London DG. ସେ 7 ପାଇଁ କହୁଛନ୍ତି ଆପଣ 7 ପରେ 8 it is a coincidence 7 ରେ ଗୋଟେ ରହି ଯାଇଛି ତ 8 ପରେ 8 9 8 9 10 କେବେ
8 9 10 ଯେ କୋନସି ଦିନ ଆସିଲା ମୁଁ
କରେକ୍ଟ ପଚାରି ଦେଇ ପାରିବେ is it possible?
Told me that from 8 and 10 he is busy for Mahanasi. I have a detailed discussion in the lunch hour.
No, more ଆଉ ଗୋଟେ purpose ଥିଲା Mr. Actually I wish that Mr. Palit would have been there. Now, since in the interim this vacation period, I have finalized the other order. I want that in the connected 3 applications where Mr. Mr. Evangeline is appearing.
The other one, Mr. Lenka.
Other one. So you could have seen that order in those lines.
I can have my associate collect the order, my lords.
Or will be uploaded to it. Because I think this point of maintainability and all that will haunt you because in your case, where the matter is pending now?
My matter is directly before your lordship. We have just got a attachment warrant of sale, attachment notice, and we are before your lordship.
So in the stage of certificate proceeding.
Yes, preliminary on the ground.
Okay.
We have not been noticed, we have not been heard.
So facts are little different. So
Facts are different. Facts are largely different. This will not fall under the category of those matters, my lords, where learned Advocate General argued before the Supreme Court and state has moved a application where they say, in fact, I have had an opportunity to go through all that. So where, my lords, the original lessees have been noticed, demand notices there, and for some reason or the other, they have kept it pending.
Mr. Palita, you were there in the last occasion also.
My lords.
That was on Thursday.
My case is a little different.
Definitely. No, I'm not there actually. I'm on a different aspect altogether. Because if that protection is there for no coercive action, that will serve the purpose till there is a adjudication, as I was telling you. Adjudication by the authority. Because now, correct. So that no coercive action will be there. Because otherwise it will be frustrated.
No, my very, very gracious.
So now, once your matter is also adjudicated by the original authority, because in your case it is not the appellate authority, it is the original authority. But still it is open for you to challenge it. Correct. So that way, that order is drawing a balance in both ways. I will
have a look at your lordship's order.
Yes. So because now every time the matter is taken up, they will raise this issue.
Let me have a look.
Mr. Lenka, I think earlier some matters, Mr. Sahoo, Mr. Lenka, they have been raising this issue regarding maintainability. So perhaps this is the reason the other matter, the Mr. Niranjan Lenka has agreed that let the matter be decided, but no coercive action. And to that extent, they also realize that they cannot register an order that till the decision that there should be no coercive action. And all points are left and kept open to be adjudicated. So that way, the order does a balance, and this struggle of identifying the issue, what happens? There is a struggle for identifying the issue.
Correct,
identifying the arguable points.
Correct.
Identifying also the question of law.
Correct.
It is in a completely, we can say, indeterminate stage.
Correct.
I mean, I don't find any flaw with either of you. But since you are saying that this demand cannot be made, they say, okay, cannot be made, but let the authority say it cannot be made. That is their simple point.
My land senior, only one point he has raised. That is, opportunity has not been given.
No. Bigger point actually troubles. Bigger point is a trouble for all three of us.
There is a underlying point
for the judge. But now, for the judge, the added issue is that authority is yet to take a decision on that.
So let me have the benefit of your lordship's order.
If you go through the orders passed by the original authority raising the demand, actually they have noted it. They have noted that this demand raised is against a person who is no more.
Dead, yes.
So it is there actually. So your records actually show that. So that
I have the records.
Yes. So it is there.
The legal heirs have been given.
So now they have straight away sent that to the legal heirs. So that is the problem. So now that is the problem they are raising. Now the authority has not given any finding on that actually.
Either way,
the authority has not given any finding.
Even the demand notice is open for challenge, my lord. Even the demand limitation is also there under the OPDR Act.
Whatever. So next comes limitation. Other point is limitation and other whether it is a
all those issues
or not. But the starting point is that they are not the persons.
Correct.
They are not the persons. The authorities have, in fact, they have noted and then send it again. For the legal heirs. So that is, in fact, that is how the truth actually.
Yeah, that we have also.
Correct. So that now this court whether can say that there's no point in discussing that aspect because the authority is yet to decide on that point.
Mal.
7th SC ମନା କରୁଛନ୍ତି ଆପଣ agree କରନ୍ତୁ ଗୋଟେ date ପାଇଁ. I have no difficulty. But special bench special bench କହିଲେ ଆଉ ଗୋଟେ problem ହେଉଛି ଯେ our matter ଗୁଡାକ it has to lapse. ମୁଁ ସିନା spill over କରିଦଉଛି. ଆର matter ଗୁଡାକ ନେଇ ହଉନି. ଆପଣ you talk to the learned AG.
ନହେଲେ 13 ତାରିଖ କେମିତି ହବ?
No, ଆପଣ Mr. Palit, you kindly talk to Mr. Lenka.
No, I'm just suggesting.
Both of you agree, even if I write.
I'm suggesting to Mr. Lenka only that how about 13th Monday? किसी असुविधा नहीं?
No, advocate general will handle this case.
हाँ, 13 जदि हवा दुईटा बेला मैं ready की
बोल. He told me to make a mention on 7th.
अच्छा, okay.
Today.
7th unfortunately court करा गोटे कौन रही ची matter. Court करा list कोटा there is a parted matter already.
Let me talk by the
So therefore, to keep all
सेटा personal appearance जी personal appear करछोनी it is difficult to adjourn those.
To keep all this confusion aside, can we have it on 13? Advocate General can have his matters.
Come back.
8, 9, 10 रे Advocate General छाड़ दियंतु 13 रे
he will be the Lord AG is leaving for Mahanadi on 8th.
I get the point. Malad, I am aware. So 13th there should not be any bench on 13th there. 8, 9, 10 3 दिन रहिला तांकरा. As Mr. Lenka suggested, 3 days he is busy.
ଆପଣ ଏବେ କଥା ହେଇ ପାରିବେ?
I go ahead.
Should I rise and come back or? Then I'm passing the order only leaving the blank.
Periodic subject to correction modification by AGs at request.
ମୁଁ 13 ବି କହୁନି ଆପଣ agree କଲେ ମତେ କହିବେ. ନହେଲେ ମତେ ଫେର again ସେ ଯୋଉ 7 ତାରିଖ matter କୁ କଣ ଏପଟ ସେପଟ କରେ 7 ତାରିଖରେ ସେ ତାଙ୍କର କିଛି contact number ଅଛି? ନାଇଁ. In person contact number ନାହିଁ. This is the problem. I mean that would not be fair to the person also. He appears in person, so.
Your Lordship, the order will be uploaded today. The other cases or tomorrow.
Yes. At least one order is ready.
At least one should be uploaded. I'll have the benefit of going through.
So number ta kete? What ready करथले कहथले?
Noted.
WPC 9263 of 2024.
WPC 9263 of 2024. 9263 of 2024. Great,
Mr. Subir Palit, senior advocate, along with Mr. Amitabh Misra for the petitioner. Your name, sir?
Sritam Mahanti.
Mr. Amitabh Misra and Mr. Sritam Mahanti for the petitioner. Mr. D.N. Linka for the opposite additional government advocate for the opposite parties. On consent of the parties, the matter was listed as directed by order dated 26/3/2026, included in the special list as directed by the एमती कौन फोटो कौन उठी आसছে কলা হইছে एमती कौन এটা কোন স্ক্যান হইছে अपलोड ହେଇନି
लास्ट ना
अच्छा as directed by order dated no notified in the special list, special cause list stuff. On consent of the parties, the matter shall be listed on dash marked at 2 p.m. About the date and talk to me. Mr. Palit, just you have Mr. Lenka's number.
No, my associate is there. He'll continue.
Upon tickets, just talk to yes, he's there, Mr. Lenka. Yes.
Please then we'll pick up.
ଆପଣ କହିଲେ କୋର୍ଟ ମାଷ୍ଟରଙ୍କୁ କହିଦେବେ ସେ କହିଦେବେ ଆପଣ 7 ନେକ୍ସଟ ଡେଟ୍ ରେ ଆଉ 2 PM ମ୍ୟାଟର କି ସେମିତି ପର୍ସନାଲ ଆଫେୟାର୍ସ ମ୍ୟାଟର କିଛି ନାହିଁ ଜଷ୍ଟ ଏ କୋଇନ୍ସିଡେନ୍ସ 7 ତାରିଖରେ ସେଟା ଅଛି
Grateful.